May please.
Yes.
Hello, I beg to mention item 34. Perhaps your lordship would require to peruse the records. In fact, my lord, this case, it was listed, my lord, my lord, I'm coming to the order. It was listed on, my lord, 22/2/24 for hearing. Now, when the matter was about to taken up for hearing, my lord, it appeared that the LCR, my lord, which has been received, my lord, it pertains to another case. So wrong LCR was, my lord, received. Then by order dated 22/2/2004, the Honorable Court made an observation, my lord, that the LCR case number, the sessions case number so and so, my lord, should be received, my lord, from the trial court, the sessions court, my lord. Now I am informed, my lord, from the registry that the reference of the sessions case, my lord, should be somewhat different because there is a mistake taken place, my lord, that the sessions itself, my lord, sessions code itself. So the case number should be, my lord, different that has been recorded in the order. If your lordship takes up the file, my lord, item 34.
In the meanwhile, another mention may be made. Somebody else may be. We will look into your.
Well,
Yes.
Maybe, Mr. Malad, I beg to mention item number 8, admission matter. Madam. Item number 8, my lord.
Yes.
This matter may kindly be taken on Monday, my lord. I have some personal problem. Admission matter.
There's
LCR has also come, my lord. Almost case is ready.
which Monday?
Next Monday.
Next Monday.
next Monday.
Next Monday. Okay.
That's
Right,
on
it's the-
this, my lord.
27th.
20.
Let it be on next Monday. That will be 1st of April.
First of all, my lord.
Heard Mr. A.R. Talukdar, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. Considering the submissions made by learned counsel, the prayer is allowed. Let this case be listed again on 1st of April.
Oh, bless me. I be blessed.
May I please, your lordship? I recommend, my lord, item number 13, my lord. CD was called early, but CD is not available today.
1-3.
1-3.
Mine.
CD. Heard Mr.
Yes, sir.
S. Rahman, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, but same has not arrived, and prays for another date for producing the same. The prayer is allowed.
Mine.
Let this matter be listed again on. When do you want? After Bihu,
After Bihu, my lord. 25th, my lord.
25th April.
Sasi Bhana to confirm.
With regard to item number 24, your lordship, this was a jail appeal. Your lordship, I have not prepared the case properly, so I just pray for accommodation today, your lordship.
Heard Mr.
A.M.
A.
Dutta.
A.M. Doctor, learned amicus curiae, who submits that he needs some more time for preparing the case and therefore prays for an adjournment. Considering the submissions, the prayer is allowed. Let this case be listed after 2 weeks. No fixed date, yes.
Must be, sir.
Yep. Yes.
Yes. Your lordship will see, my lord, order dated 22/2. I take your lordship's, my lord, to the paragraph below,
This is item number.
item 34, my lord. Your lordship will see order dated 22/2/24.
Yes.
I take your lordships to the paragraphs below, which starts, my lord, with the words accordingly. Accordingly, the proper LCR of sessions case T1 number so and so. Only, my lord, I am informed from the register that the correction is required to be made in respect of sessions case T1. It should be T2, my lord. So if it is T2, my lord, then the records can be called for. Other, my lord, the particulars will remain same, my lord.
Heard Mr. S.K. Talukdar, Item number 32,
34, man.
34. Heard Mr. S.K. Talukdar, learned counsel for the appellants, who submits that though by order dated 22/2/2024, the trial court records were called for. However, he has been informed by the registry of this court that the call for the case number of the record which was called for has been wrongly mentioned in the said order, and therefore the record could not be called for. It is submitted that the sessions case number which is required to be called for is sessions case within bracket T-2 number 117 within bracket N/2014, comma, however, in place of within bracket T-2, it was wrongly mentioned as T-1. Stop. In view of submissions made by learned counsel, let the sessions case number within bracket T-2 number 117 within bracket capital N/2014 be called for from the court of learned. Which court?
My lord, session judge number 2, Nagaon.
Session Judge number 2, Nagaon. Registry to take steps for requisitioning the aforesaid case record. Let this case be listed after 2 weeks.
My lord, can it be a date? Because we have filed a hearing, early hearing application, my lord. So, after,
23rd of April.
my lord, obliged, deeply obliged.
May I please, your lordship, my lord, I beg to mention for listing, my lord, a hearing matter. Wednesday or Thursday, my lord.
What
Then-
matter?
Hearing matter, my lord, criminal appeal hearing matter, my lord.
Okay.
My lord.
No. Which year?
2022, my lord, 3-year imprisonment.
But it has to come as per queue. If you want early,
My lord, what has happened, my lord, he is too superannuate, my lord. Yeah, PC
no,
Act.
you file
My lord, already an order was there, my lord,
for expeditious
my
hearing.
lord.
Okay.
Obliged, sir.
May I have a lordship indulgence to mention that part hard matter? It was supposed to be listed today, your lordship. But unfortunately, the order it has written 28th of April. And 28th of April, Kohima bench is closed. So that's why your 28th of April it was preponed to 21st by your lordship, 21st of March.
No, but whether you have informed the other side.
So your lordship, it is not there or in the list, it's coming on 28 only.
No.
Because order is showing. Because it was supposed to be today also.
So, I am on the question, when you are mentioning
Yes, your lordship.
out of turn,
Yes, sir.
the other side has to be informed, otherwise how?
I'll inform, if your lordship, I'll inform that.
No, you first inform them, then mention. You may mention at 2.
I'll do.
After informing, you mention.
I'll do that. I'll do.
May I please, your lordship, only item 7, I couldn't find my friend to take concern. Anyway, if I don't get my lord, let it be the last item, my lord. Because I have got 2 matters in court number 4, my lord. That's last.
May I please, your lordship? Lordship, I beg to mention item number 17 to 19 on behalf of Mr. Det Kamar.
Lordship, I'm for the respondent here. For CBI, Lordship. Lordship, we have strong objections regarding, Lordship, because the matter relates to 2012, Lordship.
Oh,
Our objection may be noted, Lordship.
no, then let it be called for.
Lordship, kindly after big vacation.
Lordship, our objection may be noted, Lordship. I leave it to your Lordship.
Whether earlier also you prayed for an adjournment.
Lordship.
Heard Miss, what's your name?
P. Soikya.
P. Soikya, who prays for an adjournment due to personal difficulty of Mr. Z. Kamar, learned senior counsel, who is leading the counsel for the petitioner, counsel for the appellant in this case. Miss
T Begum,
T. Begum.
on behalf of Mr. M. Haloy, special
Learned
PP CBI.
Counsel appearing on behalf of Mr. M. Harloy, Learned Special Public Prosecutor CBI, raises strong objections to the said and prayer for adjournment. However, considering the sub grounds mentioned by, what is the difficulty?
17 to 19.
He could not appear.
Considering the ground mentioned by the learned counsel for the appellant, the prayer is allowed. Let this matter be listed. When do you want?
Fine. Lordship may fix any date, Lordship, after.
After beautification, Lordship.
25th April.
Yes, Lordship.
Okay.
May I please, my lord? My lord, I beg to mention item number 25, my lord. My lord, the conducting counsel Kevin Pathak is out of session as of today, my lord. He has been appointed as an amicus curiae, my lord. On the earlier date, my lord, registry is directed to get a information whether the convict is still in judicial custody, and that report is there, my lord. Can it be fixed on, my lord, any other date, my lord, after beautification? 25.
Heard Mr.
Be that, my lord.
Vidas submitting on behalf of Mr. K.P.
KP
Pathak,
Pathak, amicus.
learned amicus curiae, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Considering the submissions, the prayer is allowed. Let this matter be listed.
Okay. My lord, similar prayer for item number 28, my lord.
25th of April. 28 also.
My lord.
28, you are for?
Responded, my lord.
Have you informed the petitioner side? You have to inform. Otherwise, when the matter is called up for hearing, we will take it up. You inform and then make the mention.
Yes, my lord. Perhaps my lord, CP was there at that time. I will inform them.
Mr. Y.S. Mannan is there. You inform.
Yes, madam. I will.
Item number 1.
May I please, your lordship, my lord, this is 482 application, my lord, for quashing of my lord, complaint case, my lord. Case, my lord, 12, my lord. Complaint case, my lord. And my lord, this 376, my lord, allegation, my lord, was lost before the, my lord, judicial magistrate first class, Hailakandi, my lord. And relevant portion, my lord, page 13, my lord, may I read, my lord. Page 12, my lord.
Who is the petitioner?
My lord, petitioner Komrul Islam Borbia, my lord, two accused persons, my lord, and
What is the ground?
my lord, ground, my lord, 376 allegation, my lord, not at all attract against me, my lord. May I read the affair, my lord? Can you see, my lord? And cognizance has been taken, my lord, in those sections, my lord, 376, my lord, put 2383, my lord. Even, my lord, not at all attracted against me, my lord.
Page number?
Page number 12, my lord.
Okay. Read.
May I read, my lord? The complainant had love affairs with the accused number 1 since long. On 16/10/2021 at about 8:55 p.m. in the morning, the accused number 1 through his mobile number so and so called me and asked me to come out of my house to the national highway of 134 in the link route of Buralia Mukam Kuti. Thereafter, the accused took me in a motorcycle. My
You
lord.
need not to read it. There is allegation of rape.
My lord, against the accused person, my lord. That due to love affairs, my lord, she promised, the accused number 1 promised to marry her, my lord, but subsequently he refused. That is why, my lord,
You read page 13,
13,
fourth, second line.
my lord. Second line, my lord. Thereafter, the accused took me. Accused means, my lord, accused number 1, my lord. And allegation against me, my lord, below, my lord, of page number 13, my lord. That, my
Who
lord,
are you? Miss?
my lord, I am Komrul Islam Borbia, my lord. And allegation against my lord Habibur Rahman Borbia. My lord, because my lord Habibur Rahman Borbia, between Habibur Rahman Borbia and alleged victim, my lord, there is a love affairs, my lord. So, my lord, we promised to marry her, my lord, he committed rape, my lord. That is the allegation against him, my lord. And subsequently, my lord, when refused to marry her, my lord, then, my lord, against accused number 1, this my lord lady, my lord lost the my lord, affair before the my lord Hailakandi police station, my lord. And that was compromised, my lord. And in that compromise, my lord, I took part, my lord, being a my lord middleman, my lord. That is why, my lord, my name has been inserted in this my lord complaint case. And this is my lord before the judicial magistrate, 376, not before the police, my lord. And nothing, my lord, against me, my lord, against accused number 1, my lord.
What is the stage?
My lord, appearance stage, my lord. And my lord, if I appear before the my lord landed trial court, my lord, that is judicial magistrate first class, I will put behind the bars, my lord, because 376 allegation, my lord. Kindly turn to page, my lord, 18, my lord, cognizance order, my lord. Not a single allegation against me, my lord. Page 18, my lord. Cognizance order, my lord. I am not for against accused number 1, my lord. Page 18, my lord.
My lord, regarding his allegation, my lord, Lordship may peruse page 13, my lord. Page 13, my lord, lower portion, my lord.
That I have already mentioned, my lord.
Subsequently, my lord, subsequently,
But there is no allegation of rape against.
not rape is not there, but other he has threatened the victim and thereafter, my lord, subsequently, my lord. he
That is the allegation, my lord. Because, my lord, without the presence of the victim, my lord, how police can
subsequently
compromise
on the
it?
next date, my lord, Lordship may
Just to harass, my lord. Without
so and so, I lost the case before the so and so, thereafter the accused number 2, present petitioner, approached my family members and informed that the accused number 1 will be married suicidally with me and asked not to register the said case and asked me compromise the case. The accused number 2 on the next day came to my house and threatened me and my family members and forcefully obtained my signature in a blank paper and told me that the said paper would be used for making marriage documents. But subsequently, I came to know that the accused number 2, by using the said paper containing my signature, submitted a compromise petition in the police station. That is my.
my lord, without presence of her, my lord, how can police, my lord, can compromise a case, my lord, under section
No,
376?
there are allegations against you, may not be under.
My lord,
Yes.
376.
And my lord, kindly, my lord, kindly sit, my lord, page 12, my lord. Incident, my lord, place and time of incident 16/10/2021, my lord. And page 14, my lord, case was, this my lord complaint case was, my lord, before the my lord judicial magistrate first class, my lord, 7/12/2021, my lord. There is, my lord, delay also, my lord. So, my lord, unnecessarily, my lord, because my lord, I was a middleman at that time. That is why, my lord, my name has been inserted, my lord. Nothing else, my lord. And 376 case, my lord, before it should lodge before the police station, my lord, before the judicial, before the magistrate, my lord. And without her presence, how can police can compromise a case, my lord? Your lordship knows very well. And 376 also, my lord, this is quashable, my lord. As per the judgment of the Honorable Supreme Court, may I place, my lord? I am not on that, my lord, because 376 will come against him. In that respect also, my lord, 376 is can be quashed, my lord, because
No.
there is a law affairs, my lord.
No, but you are not, that is not your case.
Yes, my lord, that is my lord. There's,
Though don't plead others'
yes,
case.
my lord.
My lord.
Yes, my lord.
You stick to your own.
Yes,
case.
my lord.
My lord.
So, my lord, at the
Third.
yes, my lord.
Heard Mr. S. What is your name?
Yes, is Shikdar, my lord.
S. H. Sigdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure. So what is your prayer?
My lord, record for the record and till then, my lord, subs. My lord,
No,
further
what
proceeding
is your
against me, my
prayer
lord.
in the criminal petition?
Yes, my lord, in respect of this petitioner only, my lord. May be quashed.
What should be quashed?
My lord, the pending criminal proceeding, my lord, against me, my lord.
The cognizance taking order under section 376 may be interfered with. That may be, but other materials may be there.
Other materials are
That is why record is required, my lord. Till then, my lord.
only notice, my lord, and
My
call
lord,
for
till
elsewhere,
then,
my lord.
no coercive action shall be taken because, my lord, unnecessary
Not at
I'll
present,
put
my
behind the bars, my lord, because even though there is my lord, no ingredients of 376, my lord, I will put behind the bars because
Other
this is
sections
pending
are
before the
applicable
judicial
against him,
magistrate
my lord.
first class, my lord. My lord, you lordship knows very well, my lord. He will not allow me to go on bail, my lord, because 376 is there. So, my lord, notice may be,
No, I will make an observation to that effect.
my lord. Otherwise, my lord, I will put behind the bars, my lord. Your lordship knows very well, my lord. That is why, my lord. Because landed judicial magistrate first class will not allow me to go on bail, my lord.
Why?
Because my lord, 376 allegation is there,
No,
my lord.
you
Not
make
against
him
him, my lord.
understand that there.
But my lord, 34 is there, my lord. Common intention, my lord, and your lordships, no, this is also not appropriate, my lord, 34.
No, 34 is not with regard to 376. It is with regard to other
That,
offenses.
well, my lord, as a whole, my lord, cognizance has been taken against me, my lord, also, my lord, accused persons, my lord. Accused person, my lord, sufficient grounds for proceeding against the accused persons under section 376.
What was the last one? Four 82 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Kamrul Islam Bardmia, praying for quashing of criminal proceeding. That is CR case number 1213/2021, pending before the Court of Learned Judicial Magistrate First Class, Hailakandi. It is submitted by Learned Counsel for the petitioner that on the basis of a complaint petition filed by the victim / complainant against the present petitioner and one Habibur Rahman Bardmia before the Court of Learned Chief Judicial Magistrate, Hailakandi, wherein it was alleged that the accused number one, namely Habibur Rahman Bardmia, had repeatedly raped the complainant / victim on several occasions. Stop. In the said complaint petition, it is also alleged that the present petitioner had approached the victim with an offer on behalf of the accused number one to compromise the case. And it is also further alleged that the present petitioner had also threatened the family members of victim and had obtained signatures of the victim on a blank paper. Stop. Learned Counsel for the petitioner has submitted that by order dated 1/7/2022, passed in CR case number 1213/2021 by the Learned Judicial Magistrate First Class, the cognizance of offense under section 376/420/323/506/34 of the Indian Penal Code was taken by the learned magistrate against both the accused persons, including the present petitioner. It is submitted by Learned Counsel for the petitioner that though the cognizance of offense under section 376 of the Indian Penal Code was also taken against the present petitioner also. However, there is no allegation made against the present petitioner regarding present petitioner under section 376 of the Indian Penal Code, as the said offense is alleged only against accused number one, that is Habibur Rahman Bardmia. You have not challenged this cognizance taking order.
Well, I am challenging whole procedure.
Whole Whole proceeding may not be quashed. Issue notice to the respondents and call for the scanned copy of the case record of CR case number 1213/2021 from the Court of Learned Judicial Magistrate First Class, Hailakandi. Since learned additional public prosecutor has appeared for the respondent number
One,
one,
ma'am.
no formal notice need to be issued to respondent number one. However, as regards respondent number two is concerned, the petitioner shall take steps for issuance of notice on respondent number two by registered post with AD within 3 days from the date of this order, returnable on after 4 weeks, give a date. Give a date. Returnable on 26th April. Stop it. Since there is no, since on the, since on the basis of the materials available on record, it appears that no allegation under section 376 of Indian Penal Code has been made against the present petitioner. Hence, the order dated 1/7/2022 passed by learned Judicial Magistrate First Class, Hailakandi in CR case number 1213/2021 to the extent of taking cognizance under section 376 of Indian Penal Code against the present petitioner. Shall not be operative till next, till the next returnable date.
Ma'am.
List this case again on 26th. of-
I love that. I love that.
Item two,
Yes.
I have prepared this application, my lord, against, my lord, order passed under the Domestic Violence Act for payment of maintenance, my lord. The order, your lordship, find at page 50, my lord.
This is an application under 482.
My lord.
Why have you come under 482? Because
Uh,
there is a specific provision in DVA for appeal against the order, any order. Is there any provision?
My
Section
lord, have not found such.
DVA, so I don't know. I think that
But I don't think there is some appellate provision under the TV Act, my lord. And we have come against our supreme order, my lord. This is not a case for domestic violence at all, my lord. Question of appellate without provision.
section 29. There is an provision for appeal,
Yes, my lord, I have not,
appeal against the,
there is a provision, specific provision.
you have
for
to
it.
have.
My lord,
Which order you are,
my lord, page 80 is the order, my lord. We have come against the interim order, my
page,
80. Annexure P6, page 80.
it is an appealable order under 29.
And my lord, since I have, my lord, not perused the order, which is appealable, my lord, lordship may kindly give me the liberty to withdraw and prefer the appeal before the
Sessions Court.
mother.
Heard, Mr.
And the delay falls, my lord, in the meantime.
There you have to file condemnation of delay.
That observation, your lordship may kindly.
No, because perhaps limitation, this
It's
section
16
5 may be applicable. If within
Limitation,
30 days you have to file.
my lord.
The period which you have lost by preferring this petition in this court may perhaps be subtracted, but otherwise for condoning delay, you have to look into the act itself. If there is no provision, then limitation act.
My lord, may I pray, my lord, to list his matter, my lord, next week, my lord, after.
For what purpose?
My lord, I want to go through it, my lord, whether, my lord, there is a provision for condemnation and etc.
But 482 does not lie.
That I have seen.
You go through, I'm listing it on Monday,
Monday is the holiday.
Monday, 1st April.
My lord,
On request of learned counsel for the petitioner, let this matter be listed on 1st of April 2024.
my lord, instead of 1st of April, my lord, prior to that, may I pray, my lord,
You suggest a date
my lord. On 28th, my lord.
on 28th April,
No, my lord, 28th
28th
March.
March 2020.
Obliged.
Item 33 from supplementary is basically.
Lordship, non-appearance, and also Lordship, up to date CD is not available, Lordship. This statement is not there in the case diary, Lordship.
None appears for the petitioner on call. Ms. N. Das, learned additional public prosecutor, has submitted that the case diary which is available in record, available is not up to date, and she prays for getting an updated case diary. The prayer is allowed. Let this matter be, when,
On Lordship, 18th of April, Lordship.
let this matter be listed again on 18th of April. The interim order shall continue till next day.
For admission, item number 3.
May I please, honorable court, my lord. Lord, on the last occasion, the additional affidavit was placed on record. And the state had taken time because they did not have the file in the court.
Lordship, after some time, Lordship, learned APP, K. Bosho will appear in this matter.
Gogoi.
K. Bosho.
Gogoi was to appear.
Today,
Gogoi had taken time.
but today. K.
Lord, I
Bosho
may
will
start, let him come, because the state is supposed to be present at any occasion before my lords. Once the court time starts, then the PP is to be present, my lord, the APP.
PPs are there, but
My lord, this is whether
we'll
X
take it.
PP is there or Y PP is there. I'll place my case, he may place his,
yes, Ms. Das, what is your submission?
Lordship,
because this
and I
way,
have
this
to
is a
inform
waste
him,
of judicial time, my lord.
Lordship, let him start, Lordship.
Okay.
confirm.
Mr. Bosho will reply. Mr.
Lordship.
Bosho will
Lordship.
reply.
The
You are
lordship
sure?
would Kindly take
You are
up,
sure that Mr.
Yes,
Bosho will reply?
Yes, Lordship.
Okay, then we can go ahead with the hearing.
Lordship.
lordship would kindly take the additional affidavit which was filed by me. What was the date? On, you haven't given the date.
Yes, there is an additional affidavit.
Additional affidavit. Now, my lordship would see in the additional affidavit, page 2, the previous IO had wanted to continue with the investigation without any materials against me. And the complaint had been filed by Sri R. Prasad IAS, but he had filed it from the excise branch and not from the revenue or land settlement branch. I've stated that specifically at page 2, my lord. So this is a land settlement matter, but the FIR had been filed by the excise branch. So based on the such FIR, Ejahat, the FIR was registered and the IO examined the petitioner as deponent, the deponent herein as the accused on 9th April 2021, which is at Annexure 14 at running page 91-93 of the main writ petition, criminal petition, regarding the involvement of irregularities made in respect of a land settlement in favor of a party, my lord, called Northeastern Agricultural Seed Farm and Research Center. Then on order of 30th January 24, passed by this court, I was issued a notice under section 41A by the present successor investigating officer, who again recorded my statement on 3rd February 24, which was nothing but a reiteration of the factual matrix already in addition to my earlier statement under section 161, which was placed by the IO in his investigation earlier, but copy was never shown or provided to me or read over to me for correction or confirmation or an inspection of the court record by me. No copy of the section 161 CRPC statement was found in the court record or certified copy of charge sheet. On 3rd February
The
24
case
also.
has been charge sheeted.
Case has been charge sheeted. I've been listed. The case was that I was listed as an accused, but not charge sheeted. So my lordship had said, would it affect me? Would it materially affect me? I'm a serving officer
Yes.
at the secretary level. So it would be a stain on my career, impeccable career for so long. Now the investigation, they were saying that the whole thing was that there was no objection certificate given by me. I said, as the charge officer at that stage of the revenue.
Before you proceed,
Lord,
in this case, FIR was lodged.
FIR was lodged.
Investigation followed.
As a matter of fact, there were 2 FIRs. One was in Bashishta Thana, which was lodged by one Mr. Dulal Bora.
Okay.
And one was by an officer of the IS from the excise department. And both the FIRs were then merged by the investigating officer and the SP of the vigilance cell. And then charge sheet was preferred on PRC.
In the charge sheet, your name was there.
I am listed as an accused,
Not sent
not
up,
charge sheeted,
not sent up for trial.
not sent up.
And an observation was made, request was made for
Further investigation,
investigation.
my lord.
Whether that request was pertaining to you specifically or
There were 4 of us. Other 3 people have retired. So even the sections under the PC Act will not be applicable to them because it is more than 4 years since the alleged offence. This incident is supposed to have taken place in 1996 when I was in the Dispur circle office as an attached officer, circle officer, for a few months. Now, whatever had been settled in favor of the main accused for the land was prior to my coming there. Now, what I have done also in this additional affidavit, I have given a case by the division bench of this court, which said at that relevant time, the no objection certificate was not required by the DC. Subsequently, there was a gazette notification which I have also annexed. Now, certain papers were not found in the charge sheet. But at the time of my
in this year when I was examined by the IO, I was shown copies and I saw that they are from the official, I would take my lordship to page 11, which is annexure E,
11 of.
page 11 of my additional affidavit. Just to point out, this document which they say was not found in the DC court's record, it has a stamp showing the Office of the Deputy Commissioner, Information and Facilitation Center, serial number 18, eligible 22 possibly. Date is 10th of November 2006.
What is this?
This, my lord, translation is at page 10. This is Circle Officer Dispute Revenue Circle. Forwarding of land transfer report. In connection with the above subject, I have the honor to state that Srimati Jamini Kalida Talukdar has submitted application praying for permission of sale of the below scheduled land of village Betkuti under Beltola Moza. The filled up form of report of physical investigation was carried out by the concerned Lat Mandal and Kanungo with regard to the application, and relevant papers and documents are forwarded herewith for necessary action. No decision was taken by me as the circle officer attached. The land is 2 biga. Now, just for a moment pausing, I'll take my lordship to the main petition. I'll take my lordship to the charge sheet, and in particular, if my lordship has the main charge sheet,
Is at page number?
53, internal page 17, 19 of 25 of the charge sheet. And the column is 17C2.
Yes,
It is pertinent to mention, if my lordship is with me,
yes.
I'll follow my lordship's pencil. Pertinent to mention that the main basis of investigation is Government Revenue Settlement Department Circular number so-and-so, dated 3rd of October 1989, serial number 4 of 17, clause 1 above, regarding restriction on leased land against transfer within a period of 5 years from date of offer of the lease. Number 2 is Government of Revenue Settlement Department letter number so-and-so, dated 6th of December 2006, serial number 5 of 17C1 above, regarding restriction on leased land against transfer of next 10 years from date of issue of settlement order. Little further down, my lordship would see column 17D. In response to notice issued by Dash dated 20th of June 2019, this is much after my time. Circle officer submitted a report by number dash dated 10th July 2019, which is much after my time, which revealed that government order number dash dated 6th of June 2005, by which government settled 4 biga 0 lesser of land covered by Dag number 91 of village so-and-so in favor of Northeast Agricultural Research, is not available with the records in hand of the circle office. Second point, government order number so-and-so in which government settled land of 3 biga 0 kata 0 lesser of land covered by Dag number 91 village Betkuti under dispute revenue circle in favor of Northeast is not available with the records in the hand. Then it is old Dag number 47 is not listed at Betkuchi Gaon under Beltola Mauza. Government circular number so-and-so dated 3rd October 1989 and government order circular number so-and-so dated 6th December 2006 is not available at circle office. 7 biga of land covered by Dag number 91 old and 321-6, 321-7 new. Pata number so-and-so is recorded in the name of Pradeep Kumar Agarwala as purchased as per order of circle officer passed in connection with miss case number so-and-so and so-and-so, which is 2010-2011, much after my time. I was not there in this office at that time. Then my lordship would see land measuring 1 biga 2 kata 15 lesser covered by Dag number 320 3238 Pata number 1931 at Bedkuchi village, recording the name of Ishwar Prasad Chaudhary in place of Northeast Agricultural Farm and Research, purchased as per order of Circle Officer passed in connection with the case number is 931 to 17 to 18, which is much after my time. Now, pausing again here for a moment, I'll take my lordship back to what paper was shown to me. This is in my additional affidavit. I'll refer to the translated copy at page 10 of my additional affidavit, annexed 2. Kindly see the schedule. Pata number 340, not mentioned in this investigation of in the charge sheet. Dag number 91 is there. 1589 is there. Area of land 2 biga. 2 biga is not even there in the charge sheet.
No, one thing. The IO has himself mentioned in the charge sheet that there is no sufficient evidence to prosecute you.
But the document which they have shown me subsequently, which is in 2024, earlier IO has mentioned in the charge sheet not sufficient evidence. My lordship had come before my lordship. They issued, what is the status of the case? Section 41A was issued to me. I appeared before the successor IO. Previous IO has retired. Just before filing of the charge sheet, he wrote this, retired and pushed off. So successor IO also examined this, showed me these papers. These papers which he showed me, which I have signed, which is the land transfer report form at page 12, and the original is at page 15. Page 15. This is signed by the Mandal also, Aminul Haq, who is not charge sheeted. The Lord Mandal who is concerned is not charge sheeted. He's also signed these documents because this is pertaining to a different type of part of land, not covered by the investigation. The land which is concern of the investigation, I have not signed any paper. So what further investigation are they going to do against me?
You are basically against the observation made by the IO for further investigation against you. What is your grievance?
My grievance is, my lord, if they have a prima facie case against me, you make me the part of the charge sheet, I will defend myself in the court, no problem. During further investigation, as they have asked for, which has been granted to them. Earlier on, it was not granted. By virtue of my lordship's order, it was granted. They did the further investigation.
Where is your name in the charge sheet?
My name in the charge sheet, my lordship would find at page 44 of my criminal petition, page 10 of the charge sheet, at column number 11. Particulars of accused person not charge sheeted,
Not charge
suspect.
sheeted.
They have named me. Then they have an observation.
Now, your name is there in the charge sheet.
Charge sheet and page 45.
In the FIR,
FIR also my name is there.
your name was there in the FIR.
FIR, but the period
No, let me
investigation
understand.
period of investigation is 2018-19. I was sitting there in 2006 in the month of November. I was there for barely a month. Prior to me, another officer who's also mentioned as charge sheeted but not proceeded against.
When the
Evidence is
ori-
insufficient,
When the original FIR was lodged,
my lord. The original FIR was lodged on 28th of May 2019. FIR 7 of 2019.
and charge sheet was filed on,
Charge sheet was filed, my lord.
Charge sheet on 6th July
6th of,
2021.
yes,
6th of
Sale,
July.
2021.
2021. 6th of July 2021, column 2 of page 35.
Where you were not charge sheeted.
My lord,
Where you were not charge sheeted.
I
Your
will
name
not charge sheeted, but I'm listed as an accused. And it's a never-ending investigation.
No, now your grievance is,
When will the investigation, my lord, We have been through this, my lordship knows, within 60 days or 90 days, we are supposed to complete the investigation, file the charge sheet. The period in which the charge sheet is focused from the documents that I've showed my lordship in column 17 is 2018 and 19. I was there in 2006. The documents they have showed me. I have not recommended sale of the land. I have not recommended settlement of the land because that was not within my power and charge of duties. That is only with the DC. The power lay only with the DC. In terms of the report,
Now, what relief you are seeking?
I am seeking that my name should be removed from the charge sheet at all. The matter should be closed against me. Why should I have the further investigation when whatever documents they
Your-
showed me?
Basically, you are seeking a relief of no further investigation against you.
What I am seeking, my lord, is that if they have no evidence against me, I should be dropped. That is the law. Before we change the law in July, then suspicion is enough. There is absolutely no reason to keep me in a lis pendency of a trial where the charges have not been framed, where they say the investigation is not completed, they need further investigation. Twice they have said so, once in 2024, once in 2019. And they have not been able to bring a single shred of evidence against me. So under what umbrella am I supposed to seek protection? Only before my lords. Frivolous investigation, no prima facie case against me. All the sections which they have mentioned, 119, 120B, 157, 420, 450, 468, 471, and section 13(1)A of the PC Act. There is not a shred of evidence against me on that.
Now, the question to be decided by this court is,
Miller,
after investigation, after a sufficient investigation was done and a charge sheet was filed, can and after no evidence was found against one of the accused
Miller,
to prosecute her,
Miller.
can the investigating authority continue with the
Miller.
investigation? That is the question.
And in favor of that, I have filed before my lordships a compilation of judgments from the Supreme Court. My lordship would find that in my lordship's file, I have given as many as 7 judgments. I have marked out the relevant paragraphs which are in my favor. If my lordship wants me to read that aloud and rely on them, I can
No,
lead my
you-
lordship to that because the
No.
essential question my lordship has summarized very succinctly and very correctly.
No, whether this.
In spite of my poor attempts at submission
No, the
my lordship
query
has-
which I have now raised, the
Miller.
question to be decided by this court,
by this court, my lord.
whether this has been answered by any of the judgment which you
My
have.
lord,
given.
in my opinion, in my submission, yes.
You can point out the relevant paragraphs where observations have been made by the.
My lord. If my lordship, if my lordship has found the list of judgments,
Yes, yes.
now on the first page of
Vishnu.
that, I have kind of summarized, say in Vishnu Kumar Shukla and another versus State of UP, I've given the citation, date of judgment at para 14 on page 4. When coupled with the fact that the police did not find any offences having been made out against the appellants under section so and so and so and so, case against appellants under section 448 so and so, filed itself on shaky ground. The respondent never objected to the above and not took any further steps. The respondent has not entered appearance before the court. The case against the appellant finds itself on shakier ground. We have the firm view that accused 2 being the undisputed so and so, criminal case filed by a respondent on the facts and circumstances amounts to clear abuse of the process of the court. That is what I am on, is on the clear abuse of the process of the court.
Para,
Moreover,
para,
my lord, this would be on para 14 at page 4 in Vishnu Kumar Shukla, and another which is the first judgment annexed by me, which my lordship, I have underlined and remarked on the clear abuse of the process of the court. That is a question on a legal basis which I am standing on. So on facts, we may differ, but it has gone into detail by relying on Ajay Kumar Ghosh versus State of Jharkhand, which talks about the essential difference in procedure of trial of warrant case and base of police reports and so and so. Not on that, but they have marked it out very in depth. They've gone into the matters. Then they've also relied on Minakshi Bala versus Sudhir Kumar, which is a 1994 SEC case. Then over there, which is at page in the list of compliance at page 6, and in the case which I'm citing, my lord, it is on page 6, para 17. The magistrate was to proceed in accordance with section 239 and 240 of the code at the time framing of charges. Under the above section, magistrate is first required to consider the police report and documents sent with it under section 173. So that all has not been done in my case till now. They've not even framed the charge sheet, nor any date has been given for arguments before framing of charges. So what I am saying is that the due process of law is not being followed in this case for whatever reason.
No.
That is where I'm
Your
seeking
case is a
interference.
different case. In your case, against you, no charge sheet has been laid till now.
No, when the further investigation comes, supplementary charge sheet will be filed, let us assume.
It
Let
has
us
not
assume.
yet been filed.
Let us assume this. So by what level should the further investigation be closed? Because in a regular investigation, we have 60 and 90 days. Even 180
No,
days.
that is my query to you. Where,
I have cooperated thoroughly for, I don't know how many years they have examined me. I have cooperated thoroughly, they found no evidence. Yet they don't drop me from the charge sheet. Yet they want further investigation.
no, therefore.
When there
show-
is no investigation found
No,
by
Mr.
My
Chaudhary,
lord.
therefore show me the authority on which you are
My lord,
relying,
the-
which says that you cannot continue with the further investigation till unlimited time.
I have in a very,
Because this case
My lord.
relates to a,
my lord,
facts are where the
The-
charge sheet has been laid against the accused.
what
In-
I relied on this matter of Shukla's case was the due process of law. Which my lordship under 482 can look into, due process of law having been followed properly or not. I have submitted very poorly, my lord. So I leave it to my lordship's wisdom on the due process of law. Then
Okay, then,
it has cited a number of cases, my lord, which is over there, which I felt certain parts of it related to my case. The second case which I relied on was Abhishek Saxena versus State of UP, which is appeal, which the date of judgment was 28th November 2023. Where at para 4 and page 2, Supreme Court finding when they've carefully gone through the materials in the court, having gone through the charge sheet and other materials in the court, they could not find the necessary ingredients to attract the offense, which is my case. They could not find the necessary necessary ingredients to attract the offenses under section 119, 120B, 167, 420, 468 and 471 and 13(1)(a) of the PC Act.
this also does not help you.
In my opinion, my lord, they've not found the materials to support any ingredients for the sections cited against me.
This, the IO is himself saying that there is no
No
material.
sufficient
against-
evidence. Now, he has repeatedly said that the records have not been found in the deputy collector's office. Where will he produce the records? My question is, if the records themselves have vanished, maybe in the shifting from the DC's office from this location to another location.
No, no,
Whatever it is not in my control, it is not in the IO's control.
no,
The
Mr.
DC,
Listen to my query.
Lord.
I must understand.
My lord.
Unless I understand your submissions, it will not help
my lord,
take you to any.
I will try to.
Now, the query, the question to be answered by this court, I have framed
My lord.
that whether for unlimited period of time, further investigation can proceed. That is the question before us.
And the
Because,
rider is there, my lord. If I may say so, if I
yes,
may
what-
interrupt, my lord.
yes, what is the right?
The rider is that the police investigation has found no records available to this case. With the authority that has the jurisdiction to hold these records as a part of the record,
Okay,
which is the land settlement branch of the DC's office. The deputy collector or the deputy commissioner's office
in whichever fashion he sits under whichever hat, he's supposed to maintain these records.
No records have been.
I have also filed, in my criminal petition, I have filed RTI applications, where they have also replied to my RTI application that no such record is there. That is why I approached this court, which is why I'm cooperating with the police. Who has taken those records, where are those records, is not my concern. I'm only concerned that these sections cited in the charge sheet are not applicable to me till they find the records they can file a separate case at some other stage. This case need not be there against me. For this case, what records they have found, they have charge sheeted 2 accused.
Okay.
They've proposed charges against 2 accused. They have not framed the charges by the prosecution has not placed these charges before the court of cognizance. But I am left neither here nor there. They are saying on one hand that the records are not with them. On the other hand, they have mentioned that they have seized some records, but they cannot produce those records. I've got a certified copy of the charge sheet.
No.
Those records which they
Have
claim
you
to
cited any case
Miller.
where the facts are similar to your case?
No, Miller, there is no similar fact. We are in criminal law, and each case is separate on each fact. We cannot have duplicate facts,
the
Miller.
case which you are relying,
These I'm relying on the observations of the courts where
but
due
it relates
process
to
of law.
different facts. The facts are where the charge sheet was filed against the accused. In your case, you are not a charge sheeted accused. Your
Miller,
only grievance is
I'm putting that aside. I'm just going on the obiter dicta. What has come out as the Supreme Court having said to protect me as an accused who is totally without any charges against me, without any materials against me. So why am I an accused?
why the investigation is proceeding.
Why is the investigation proceeding when they are saying there is no material? They've admitted twice.
So show
So
me,
when they get the material, let them file a fresh FIR. But should I wait with a sword of Damocles over my neck? In matters like this, my lord has to step into the full frame of the quashing.
after this filing of charge sheet,
My lord.
any supplementary report has been filed?
No.
Nothing.
No, in fact, it has not even affected my, I've been promoted because they found nothing in the internal inquiry initiated by them. They found no material against me. But that is, of course, an internal administrative inquiry, nothing to do with
Whether
the
the IO was granted permission, any leave to continue with the
No,
further
but
investigation?
not in the first time when he retired. The SP in the scanned copy of the lower court record had simply mentioned that the IO has retired. No specific permission was given to continue the investigation. Subsequently, they appointed another successor IO. There also I could not find, maybe my reading of the law is not as exhaustive as my lord or my friend.
The query was posed, Mr. Basho, on last occasion,
Lordship.
whether further investigation is
Yes,
on.
Lordship, the investigation is continuing. Lordship, in this regard,
No.
they have placed one letter to us also, Lordship.
My friend has perhaps not understood the question. In continuing an investigation, a specific permission has to be given and brought on record. The letter which my friend is referring to, a copy was given by them to us here last time. It is simply a letter from the police cell to their office saying that the investigation is continuing. The specific permission that my lordship and I might understand is not there on record. It needs to be there on record. That they have failed to do in 2019, they failed to do that in 2024. And they cannot do it without giving germane reasons. They have to give genuine reasons. This is just an internal letter administratively from an officer of the police who's supposed to be responsible, writing to my friend and my friend's office saying that we are continuing the investigation. It's neither here nor there. It's not as per the CRPC, which requires a specific permission. And that too by the SP, not by the magistrate. I may be incorrect in my submission of the law. My memory may be a little faulty on that. My friend can correct me. I'll be very happy to get the correction, but this is what I understood as the law when it was submitted before my lordship.
Okay, what are the other relied upon cases?
Milord, I relied in order of 31st August 2023, Abhishek was a state of Madhya Pradesh. When I filed this,
Which para?
para 12 at page 10, which is relied on Bhajan Lal's case, which says that if the court thinks fit regard having to the parameters of quashing and self-restraint imposed by law, more particular the parameters relied by the court in R.P. Kapoor versus State of Punjab 1960, which is an old case, the court would have jurisdiction to quash the FIR and the complaint. I've relied on that observation of the court, my lord.
But you are not praying for either quashing of the FIR or
The FIR, my lord, having named me, when no material is found, it's an automatic prayer even at the bar, my lord. I don't have to specifically write it in a criminal petition, my lord. In criminal law, submissions at the bar, my lord, has the same, because here we are talking about an accused. An accused has full right to protection under 21 of the Constitution. You cannot hold me guilty of something which I have not done. I am protected by 2021. I may be incorrect about the constitutional matter, a little memory problem nowadays. But forgive me.
what else?
Then, my lords, we come to the fact that the Supreme Court has gone through Bhajan Lal's case and on the legal principles proposed to Section 482, that an accused come before the High Court invoking either inherent power under 482 or the extraordinary jurisdiction under 226 of the Constitution to get the FIR or criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motives of wreaking vengeance. Then in such circumstances, the High Court owes a duty to look into the FIR with care and a little more closely. But that's a duty cast on my lord, my lord. It's for me, it's my duty to simply point it out to my lord in assistance. It will not be enough for the court to look into the averments made in the FIR of the complaint alone for the purpose of ascertaining whether the necessary ingredients constitute the alleged offence are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be with due care and circumspection to try and read between the lines. That relies on Bhajan Lal, my lord. The court had set out by way of illustration the broad categories in which the inherent power under Section 482 could be exist. The exercise para 102 of the decision reads that follows, and I didn't reproduce that. Para 22 interprets the categories of Bhajan Lal, where the apex court holds the case at hand, like the present case. Given the totality of the facts and circumstances, we are of the considered opinion that Bhavna's allegations against the appellants, such as they are wholly insufficient and prima facie do not make out a case against them. Further, they are so far-fetched and improbable that no prudent person can conclude that there are sufficient grounds to proceed against them. That is exactly what I'm saying in my case. In effect, the case on hand falls squarely in the categories 1 and 5 set out in Bhajan Lal Supra. Permitted the criminal process to go on against the appellants in such a situation would therefore result in clear and patent injustice. It's a fit case for the High Court to exercise its inherent powers under Section 482 to quash the FIR and consequential proceedings. This is what I was thrusting on, my lord. In Mehmood Ali, which is a 2023 case, where at para 13, page 9, para 14, page 9, it refers to the state of Andhra Pradesh where the Golconda Lingaswamy. Only such materials that are manifestly fails to prove the accusation in the FIR can be considered for quashing the FIR. There are no materials that are manifesting proving accusations in the FIR. Everything in their charge sheet is failing to prove everything accusation in the FIR. They've not been able to bring out a single shred of evidence against me. So it deserves to be quashed, my lord. In Golconda Lingaswamy, which is a 2004 case, at para 5 on page 526 and para 6 at page 527, referring to R.P. Kapoor versus State of Punjab 1960, the earlier case, which
Where-
relied on Bhajan Lal.
Where
Consistently, what they're showing is, my lord,
are you reading at which?
my lord, I'm at page 3 of my list of judgments. I've just paraphrased certain parts which I feel I should rely on rather than take my lordship to the entire judgment. But what I wanted to say was, my lord, is that consistently the courts have followed the Bhajan Lal principles, my lord, as on date. Frivolous, vexatious matters, manifest the error on the apparent on the face of the record, no materials to support the FIR, no evidence found in
What
the
is there
fact
in the third judgment which you have relied? State of Gujarat versus Dilip Singh ji?
state of Gujarat, my lord.
Or are you relying on any other judgment? You have
My
cited,
lord, I've just relied on these which I could find, my lord,
you
that
have
time.
cited 7 judgments.
7 judgments. Because more than that, my lord, would confuse my case, even to me. There are other matters which have come up actually in between, but on live law and all that.
Any judgments which is cited by you specifically says that the investigating agency cannot continue further investigation for unlimited period of time.
What my understanding, my lord, is from the general principles that the materials not found against me closes the case against me. That they have failed to do.
Okay.
That they have
When
failed to
after
do.
investigation,
My lordship would want the specific sections from the CRPC, I'll provide that. 173 is what we normally rely on.
so your one leg of submission is that once during investigation nothing was found,
I'll put a counter question to my lordship. Suppose
you have
under
to answer.
173, they're supposed to finish the investigation. 167, 867, they're supposed to finish within 90 days. They don't do it. They don't ask for permission to continue. They're relying on 173 also to continue the investigation. Where does it stop?
No, that is my query to.
Where is the stop? That is for my lordship to answer and for my lord, for me to place before my lordship. What they are doing is they are trying to find a lacunae in that interpretation, which I fail to see in any, because they have not filed any reply. They submitted, I've heard their submissions here. I've heard their submissions in
So
the
your
trial
submission
court.
is once materials are not found, the only option is to close
To
the
close the
investigation
matter
and drop
against
the
me.
lid. Okay.
As I'm a serving government servant, so the PC Act is also applicable. So that also is not applicable in this case because no material is found.
Yes, Mr. Bashir.
Yes, Lordship. Lordship, it is, the search sheet is filed on 6/7/2021. Lordship. Search sheet submitted
Yes.
on 6/7/2021. Lordship, as per the query that is made by this honorable court, we have received the letter, Lordship, on 4th of February 2024. There, they have stated, it is the search sheet dated was, it is the 6/7/2021. After the search sheet was submitted, during that search sheet, 2 number of accused person, Jamini Kolita and another one is Dilip Kumar Kolita, they were the search sheeted person. Further, Bhaskar Setri, Secretary, Northeast Agriculture Seed Farm and Research Center, was arrested on 17/10/2021. Lordship. So that is the after submission of the search sheet. On 7/10/2021, another accused who was arrested.
What is his name?
Lordship, Bhaskar Setri. Bhaskar Setri, that is mentioned here as. But sorry, here it is stated as only Bhaskar Setri. Bhaskar Setri, who is the secretary of one Northeast Agriculture Seed Farm and Research Center. And they have stated that in respect of Kobita Deka, on 3/2/2024, she was interrogated and recorded her statement. Lordship, when this search sheet was submitted, Lordship,
When Kavita Deka was interrogated?
Kobita Deka was interrogated, Lordship,
Additional affidavit, I've given the date.
3/2/2024, Lordship, 3rd of February, Lordship,
3rd of February, and prior to that, my lord,
2024.
prior to that, 9th April 2021. And in both the interrogations or examinations, I was not found connected to any of the three accused that he has mentioned. They found no material connecting us,
Okay, let Mr. Bosho.
and neither have they confronted us, my lord.
Yes.
Lordship. Lordship, when the search sheet was submitted, the IO in his part, Lordship, the first thing is that it is stated that the so-and-so is not search sheeted. So that is the thing. But during the search sheet when that was filed, it is clearly stated that the instant case of so-and-so, the name of the scenario is also here. That however, efforts are not are on to collect credible evidence against them. In view of above, investigation will be continued as per provision of section 173 8 CRPC to collect further evidence against so-and-so. Here the name of Kavita Dekai is also here. Lordship. Now, Lordship, the question is that what Lordship has asked the query, whether when there is the person he is not search-sheeted, in that case, by filing a criminal petition where we can stop an investigation for further investigation. The whether that we can stop an investigation when she was not search-sheeted, because she is not search-sheeted, but we cannot make any stoppel regarding the future investigation. And she was the attached, you're the circle officer in this regard. And that application, that the FIR was lodged on the basis of a government servant himself from the Secretary Revenue. And
You missed my earlier submission.
yes,
He filed it as, if I'm sorry, I'm just assisting my friend. He
no,
he filed it as R Prasad IAS complainant.
yes,
A jar alphanumeric number was sent to from the excise branch, not from the settlement or the revenue.
no,
branch.
he was that time the Principal
I
Secretary,
know.
Govt of Assam Revenue and Disaster Management Authority.
See the FIR, it's from the excise branch. That's why I raised this question to you. It's from the excise branch, not from the revenue or settlement branch, or for the land records or anything. The FIR you'll find the FIR
But it is
at page, where is the FIR?
Lordship in the search sheet, page number 38 also.
Find the FIR. It's there in the chart sheet.
Page number 38, Lordship.
Yes.
Here also it is stated that confidential letter of Sri Rajesh Prasad IAS, Principal Secretary to Govt of Assam, Revenue and Disaster Management Department, by so-and-so, dated this to so-and-so, addressed to the Director Anti-Corruption and Vigilance Assam, Rupnagar, Guwahati, so-and-so, on the subject criminal proceeding against key person, office bearers of Northeast Agriculture Seed Pharma and Research Center, so-and-so, so-and-so. So that was filed by the address by the department itself. That is the Principal Secretary to the Govt of Assam, Revenue and Disaster Management.
Where is the original letter? My lordship would find that at page
No, I have.
76, Annex 7.
Then thereafter, what is the submission?
Lordship, so as because the person was not search-sheeted, Lordship, we cannot stop the investigation. Maybe in the long run, some records may be available that period, because it will be a supplementary search sheet that will be submitted by the investigating agency.
Anything, any reply, Mr. Chaudhary?
Milord, point to be taken, Milord, is that on the basis of the FIR, which is at page 76, Annex 7, what materials that have been listed over there, then we come to the charge sheet itself, which is the FIR. From the HR, we had the FIR of 28th May, June 20th May 2019, followed by the charge sheet of 6th of July 2021. all these investigations have not revealed any materials against me based on the FIR. So if they want to have further investigation, they're welcome to continue. They themselves have said that they have not found the records pertaining to the allegations in the FIR related to these sections and these sections which they have filed the charge sheet under. So as far as they are concerned, for the FIR which has been lodged, the HR which has been lodged and the FIR which is registered and the charge sheet which has been filed, 3 principal accused have been listed by them, which he has named. In fact, I think in Chetri's case, they have also taken a 164 statement, which is in a sealed cover before the magistrate below. Now, in all these 3 accused, not a single shred of whisper of evidence is there against me in connection with them. So conspiracy doesn't lie. So if they find any material according to what they feel is my role based as the officiating charge in charge of the Dispur circle at that stage for that 1 month, for any document filed between the 10th and between 1st and the 11th, 16th of November 2006, which I have annexed in my additional affidavit, but I'm enlarging the time frame also for their convenience. In that period, the judgment which is annexed by me at page 16, annexure 4, a judgment passed by this honorable court in the division bench. It says that no objection certificate is not required by the DC. Subsequently, they brought out a government notification in 2009, which says that there is to be a no objections. They've amended no registration of non-testimony without no objection certificate. That is 21A. Now, all this happened after I had left the charge. So how are they trying to pin my actions as a in charge officer at that stage, as a attached officer, to their present investigation? Where is my role? They have not been able to explain. And without explaining my role or my connection to any of the other accused, under what umbrella or what circumstances are they keeping me lumped with the other accused? I would like my friend to answer that. I mean, simply reading out my letters, which instructions to him actually.
Lordship, annexure
It's not
7
part
of
of
the
the-
petition, Lordship.
It's not part of the court
Annexure
record.
7 of the petition, page 76, Lordship.
Wait, 76 देखो. There he is.
Yes.
So, Lordship, it is a letter dated 15th of November 2018 from the end of the Revenue and Disaster Management Department, Rajesh Prasad IAS, to the Divisional Commissioner, Lower Assam Division, Panbazar. Subject is proceeding against irregular orders of mutation settlement. Lordship, here I am not going to the entire part. Lordship, may kindly see the page 77, Lordship. Lordship, may I read it out?
Yes, para 9.
Lordship, yes, para 9 and Lordship before that, para 8, Lordship. The violation
But
involved are,
after this investigation was done. after
yes,
this
Lordship,
letter-
and then there it is very clearly stated that who is the Lordship, the petition
But
in this
nothing
case.
was found
Lordship,
after
at
this.
that stage,
After
Lordship.
this
So
letter,
they,
this letter is of 2018.
18.
18, Lordship,
2018, after this investigation was done till 2021.
21, Lordship. On
Nothing was
21,
found
Facet
against the
submitted,
petitioner.
Lordship.
Nothing was found against the petitioner.
Lordship, they were not able. So they are, they stated that supplementary receipt may be submitted in later state.
Okay. So have you finished, both of you?
My lord, I would
You have to finish.
again, I would again,
At some point of time, you have to
I am
conclude.
finishing that. I would firstly remind my friend and the court that an FIR, Ejar complaint starts the process. An FIR is then registered with the presses there about what the allegations are, which goes in for the investigation. Then the charge sheet is filed. If no material is found to support the complaint,
That question I have to answer.
my lord. Precisely, my lordship is centered on that.
Heard Mr. P. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Hearing concluded, judgment reserved.
Lordship, in the
Judgment.
meanwhile, if I also get some authorities, I will also place.
Yes. Please give me a copy also.
Yes. Sure.
Deeply obliged to my lordship for the patient hearing.
The two chamber of the
May I please, my lord? This is a case of concurrent finding. Because
What is this? This IA is for? There is a,
For state of the judgment, my lord, I'm for the respondent side and he's the petitioner, president petitioner.
no, I am the petitioner, my lord. Perhaps the leave may not be granted in this case.
this is against the acquittal.
No, this is not against the acquittal, my lord. This is the judgment against the concurrent finding.
But
Because
particular-
both the trial court as well as the appellate court has held the present appellant has been guilty of committing an offence under section 138 of the Negotiable Instrument Act.
Okay.
But in the meantime, my lord, this honorable court was pleased to ask for the LCR, and both the LCR has arrived before this court. So I am praying, my lord, so a date may be fixed for hearing on this matter.
Nothing, my lord, in the appellate court also, the appellate court also should have directed the appellant, the present petitioner to deposit at least 20% of the check, the final amount that under section 148 of the NI Act, but that was not done.
Now, whether this revision
that
petition
would
has
be
been
this-
admitted or not.
No, this case has been.
Not yet admitted, not yet admitted. Today is for admission, my lord.
Admission.
So, my lord, matter may be fixed for hearing as per my lord, request of the my lord petitioner said, but subject to my lord deposit of the minimum 20% of this fine amount under section 148 of the NI Act.
Yes, what do you say?
No, my lord, when this particular appeal has been filed, this particular law has not been enforced. So I am requesting my lord to fix
No,
a very
no,
short date, my lord.
I am not understanding your submission. What law was not enforced?
My lord, 148.
That
which is-
was
which is a
enforced.
recent amendment to the act of an act. Now, my lord, that law was not enforced when this particular appeal has been
That
filed.
was not enforced.
That was not enforced.
When it
Because
came,
this is an appeal that has been preferred in 2019. But
No.
this particular law has come thereafter.
when?
In 2018, my lord, it came into effect, my lord, on 1/9/2018. 2018. amendment. By 2018 amendment, my lord, this section 148 was inserted in the NI Act.
2018. Then my lord, these actually.
And the petition was filed in
Then when we
2019.
have
Then you file 20%.
20%. 20%.
Heard, Mr.
For respondent number, private respondent number, MIS number.
Heard, Mr.
B.
B.
Deccan.
Decca,
Be the can.
learned counsel for the revisionist. Learned counsel for the petitioner. Also heard Mr. M. A. Islam, learned counsel for the respondent number.
2, private respondent. Here respondent number 1, my lord, it doesn't shown as respondent number 1, but private respondent.
Counsel for the respondent number 1. The the trial court record as well as first appellate court record, which were called for in this case, has arrived. And this case is ready for hearing. However, it appears that this criminal petition, this criminal revision petition is yet to be admitted for hearing. Learned counsel for the respondent has submitted that the petitioner was sentenced by both the trial court as well as first appellate court to pay a fine of rupees
5 lakh one,
5 lakhs.
5 lakhs.
with
For a check amount of 3 lakhs.
5 lakh one.
5 lakhs. And he prays that a condition. Putul, in a-
Section 148, man, 148.
a condition in pursuant to section 148 of the
And I.
Negotiable Instrument Act 1881 may be imposed for admitting this revision petition, and the petitioner may be directed to pay 20% of the fine amount as a condition for admitting this revision petition. Learned counsel for the respondent, learned counsel for the petitioner does not raises any objection to the said prayer. Hence, it is directed that when will you submit?
My lord, let me have 1 month time. 4 weeks.
Okay. It is directed that the petitioner shall deposit 20% of the fine amount to the registry of this court within a period of 4 weeks from the date of this order. List thereafter.
For hearing, my lord. For hearing.
Let him
For
let
order.
him deposit
Lordship.
the fine amount,
My lord.
then it will go for hearing. It will again come for orders.
Lordship. Acknowledgement.
Item 6. Have you-
যেহেতু CAD হয়েছে, এবার
Night, please, your lord. My lord, these two applications against the same opposite party, my lord.
who is
For
for
a
the,
application for questioning of NI case, my lord. My lord may take up 643, my lord. Kindly
Six-
come to order dated
643?
my lord. That is item 6, my lord.
Yes.
Kindly come to order dated 20 February 24, my lord.
Yes.
Here, my lord, the other side has submitted that they will file the Vakalatnama, and thereafter we will file the copy of the petition to the opposite party, my lord. And kindly perish the office note, I have flagged it on 19 March, my lord. Till that they have not filed the Vakalatnama.
Okay, what will happen now?
So it may be taken up after 2 weeks, like that. So they are absent today, my lord.
Heard Mr.
Ji,
G. Busho, learned counsel for the petitioner. Stop. None has appeared for the respondent. It appears from order dated 22 to 2024 that Mr. N.K. Murray had appeared on that day for respondent side and prayed for some time for submitting the Wakalatnama, and has also undertaken to submit the Wakalatnama within a week time. However, from the office note dated 19/3/2024, it appears that no Wakalatnama on behalf of the sole respondent has been yet submitted. Considering the circumstances, stop. Let 2 weeks more time maybe 2 weeks time more. 2 weeks more time is given to the respondent side to submit the Wakalatnama. Let this matter be listed after 2 weeks. The interim order is there.
Yes, madam, in both the cases,
Interim order shall continue till next day.
in same order in both the cases.
Common order.
Deeply obliged.
Item number 9.
My lord, this is the jail appeal, my lord. Amicus curiae is to be appointed.
this this criminal appeal within bracket jail has been registered on receipt of an on receipt of an appeal petition by the appellant Srimati Reema Mukherjee, who has been detained in district jail Gwalpara presently. As she is serving out the sentence which has been imposed on her by the judgment an order dated 11/3/2022 passed by learned additional session judge number 2, Kamrup Metro, Guwahati, in NDPS case number 45/2019. Stop. In this appeal, the appellant has impugned the said judgment. By the said judgment, learned trial court has convicted the appellant and one Jamaluddin under section 20B within bracket small b within bracket small Roman 2 within bracket capital C of the NDPS Act, 1985, and has sentenced them to undergo rigorous imprisonment for 10 years with a fine of ₹1 lakh, and in default of payment of fine to undergo simple imprisonment for 1 year. Since this is a jail appeal preferred by the appellant who is presently detained in custody, this court intends to appoint an legal aid counsel. Any legal aid counsel? Yes. Mr.
Otherwise, I'm going to Microsoft.
Your name is there in the,
My lord, in the amicus list, my name is there.
what is the difference between two lists?
My lord, the legal services authorities are appointing the legal aid councils, my lord.
Okay.
And the amicus are being appointed by the High Court.
High Court.
By the registry of the High Court.
So High Court cannot appoint legal aid.
No, well, my lord, they can.
No, just I want to understand.
My lord, in some of the cases, my lord, we have been told that the legal aid councils are separate from those who are in the amicus, because we are only given in the division bench, my lord. Our name appears only in the division bench, my lord, but the legal aid councils are appearing in the single bench, my lord.
Oh, yes, any single bench amicus is there, whose name is. Because there is a.
Well, I may be appointed because otherwise, my lord, other courts are granting me, my lord, that is wherein, my lord, the appellants are not appearing, my lord.
Okay, when you are volunteering,
Yes, my lord. I'm volunteering taking.
but there is a list, separate list of amicus curiae for single bench.
Yes, my lord.
Anybody is present who is in the panel of list. Okay. What was the last one? And this court intend to appoint an amicus curiae to defend the cause of the appellant in this appeal, and accordingly, Mr. Atal Tiwari is hereby appointed as amicus curiae to defend the cause of the appellant Nima Mukherjee in this appeal. The registry shall provide a provide all necessary papers to the learned amicus curiae. Let the case record of NDPS case number 45/2019 be called for from the Court of Learned Additional Session Judge number 2, Kamrup Metro, Guwahati. The registry shall take steps for requisitioning the-
Piracy paper book is also required.
after arrival of Yes. Let this case be listed after arrival of the trial court report.
Item 10.
May I pronounce it? This petition has been filed by the petitioner who happens to be wife of the respondent. The facts are as that Lordship, while a divorce petition was under consideration at Rohini Court in Delhi, and before disposal of that, again a divorce petition was filed by the respondent husband in the trial court at Kamrup Metro Family Court. So on receiving the notice and knowing the fact that already a divorce petition is under consideration at the court at Delhi,
This is an appeal against,
yes,
but appeal
341.
in family court matters lies before the division bench.
Lordship, in the family court, on knowing this fact, an application under 340 was filed, but the same was not entertained by the court below. So I am here before this honorable court under section 341 of the CRPC.
341. It is there in read section 341.
Yes, Lordship. Any person on whose application any court other than a high court has refused to make a complaint under subsection 1 of the subsection 2 of section 340, or against whom such a complaint has been made by such court may appeal to the court to which such former court is subordinate within the meaning of subsection 4 of section 195, and the superior court may thereupon, after notice to the parties concerned, direct the withdrawal of the complaint, or as the case may be, making of the complaint.
Okay, you preferred an application under section 340
at court below.
before the family court.
Yes.
Alleging what?
That during the pendency of the divorce petition at Delhi, the husband has again filed a petition suppressing the facts there.
Okay.
And Lordship, on my filing section under 340, and on very first date I filed there, and on knowing this, the husband filed a withdrawal petition before the family court for this case, accepting that the case is being going on there, but he has been not aware of that for certain circumstances he has mentioned. And therefore the court allowed him to withdraw the divorce petition filed before the Kamrup Metro Family Court. But my application under section 340, which was filed, was not entertained. And I also went to High Court before under 115 of the CPC.
Thereafter, what
But the court there observed that I should have been gone under section 341 instead of.
Where is that order?
At page 26. Relevant portion is at para 8.
No, your 340 petition, the family court did not entertain means it passed an order.
Did not pass an order. It was neither a negative nor positive order was passed.
No order was passed.
No order was passed. Thereafter, after coming to High Court, I again went to the family court filing a petition that my matter is long pending and it has not entertained by this honorable court. But that petition was dismissed.
Heard, Mr.
ML Pandya.
M.L. Pandya, learned counsel for the petitioner. This appeal has been preferred by the petitioner, namely by the appellant, namely Neha Agarwal, under section 341 of the Code of Criminal Procedure, 1973. Where is the order passed by family court? Which order you are impugning?
It is on page 10 and but the final petition is on page 18.
No, the family court's order on your 340 petition. The order which you are impugning.
Finally, it was passed on, it is on page 18 also, on 2nd February. When I again filed the petition for entertaining the long pending matter.
What was the last one? (1973) on refusal of the family court. Family court number 3, Kamrup Metro, Guwahati, to entertain an application filed by the appellant under section 340 of the Code of Criminal Procedure against the respondent, against the sole respondent. Stop. Issue notice to the respondent. The appellant shall take steps by registered post. Appellant shall take step for issuance of notice on the sole respondent by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Let this case be listed after 4 weeks.
Obliged.
I'm taking a short break.
May I please, your lordship?
32 to.
Lordship.
Yes.
Lordship, this is an. Lordship, this is an appeal against the order of conviction against the appellant that has been passed by the learned Session Judge Majuli on 22nd of December 2023, whereby the appellant has been convicted under section 380 of the Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment of 3 years, along with a fine of 10,000, and in default, 2 years simple imprisonment.
Heard, Mr. What is your name?
A. Khan.
A. Khan, learned counsel for the appellant. This appeal under section 374 within bracket 2 of the Code of Criminal Procedure, 1973, has been filed by the appellant, Shri Marna Pegu, impugning the judgment and order dated 22/12/2023, passed by learned Sessions Judge Majuli in Sessions case number 29/2023, whereby the present appellant has been convicted under section 380 of the Indian Penal Code and has been sentenced to undergo simple imprisonment for 3 years and to pay a fine of rupees 10,000. And in default of payment of fine, to undergo further simple imprisonment for 2 months. This appeal is admitted for hearing. Issue notice to the respondents and call for the record of sessions case number 29/2023 from the Court of Learned Sessions Judge Manjuli. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. The registry to take steps for requisitioning the trial court record list accordingly.
Lordship, there is an IA also, Lordship.
Two is that? One is disposal.
One disposal.
One was for continuation of delay.
delay.
You have been,
My lord, 3 years conviction, my lord. Perhaps he is in previous bill.
No, he is in the jail.
In the jail.
From the date of the order on sentence. he
Judgment,
is
my
in
lord.
jail.
will,
From the date of judgment. he
In
is-
normally, my lord, 3 years conviction, it is previous bill. Petitions be allowed in the previous bill.
That was inadvertently not filed there.
Or not filed, that's why they are in jail.
on what ground? Oh. Yeah, only 3 years punishment. Now, what is your submission on this?
My submission is, we are only record already called for, my lord. After receipt of answer, my lord, we consider their prayer, my lord. In otherwise, my lord.
What is
And
your submission?
Lordship, if I may submit, actually, your Lordship, my submission is that this is a false case. The appellant, he has been just trapped in this case. If your Lordship allows me to just take you through the petition, your Lordship. Your Lordship, if your Lordship may kindly come to page 72 of my petition, your Lordship. This is a part of the judgment that was passed, your Lordship.
P89 clause 3 is applicable to which court? Trial court or appellate court? Trial court.
Thanks, Lord. It is for the trial court, your Lordship.
No, you have not prayed for,
My
because
lord,
it was
my
for
lord.
3 years only. You
Lordship.
could have got bail before the trial.
Before the
Lord,
trial.
inadvertently, that was not done, your Lordship. So, your Lordship, I am relying on.
389 subsection 3, my lord. 389 subsection 3, my lord.
It is for the trial court.
My
Trial
lord,
court,
my
your
lord.
Lordship.
If
Lordship,
they are satisfied, then they are in previous.
Yes.
Lordship, I am pressing, since he is already in jail now. So I'm
Since when you are in jail?
since the date of the judgment, 22/12/2023.
Yes.
Lordship is an illiterate farmer, your Lordship, and the only sole bread earner of the family.
No on merit?
Lordship,
On merit?
yes, your Lordship. Lordship, if your Lordship may kindly come to page 72 of the petition, your Lordship, of the appeal. It is the part of the judgment, your Lordship.
No.
Page 72. Para 2, if I may read, your Lordship, of the judgment.
Yes.
Lordship,
it states, on receipt of an Ezahar dated 3/3/2023 filed by the informant, Wahidul Islam, and the said case was duly registered, and the IO carried out the investigation. The IO visited the PO, drawn a rough sketch map, and recorded the statement of witnesses under 161 CRPC. The IO seized articles so and so,
What was the stolen property?
Mobile man.
mobile
One
phones,
mobile handset.
Mobile.
2 mobile handsets. Now, your lordship, as per the prosecution case, the case is that first and foremost, the Azhar was lost, then the investigation was done. After that, the seizure was done, and then the
What
arrest.
is 413, section 413?
That is a habitual offender, your lordship.
It is triable by Sessions Court.
My lord.
Lordship.
Why this case was tried by Sessions Court?
Because your lordship, the 380,
380 is triable by Sessions Court.
no. 387
So why this trial took place in
For what
before
trial?
session? 380 is not triable by Sessions Court.
Yes, your lordship, 413 is 10 years, your lordship. 10 years.
By which court it is triable?
Sessions Court, your lordship.
Sessions Court,
See,
413.
My lord.
So because of 413, this case was tried
Tried by the
Mine.
Sessions Court,
session, but
and I was acquitted under for
413.
303.
You were convicted under 380. only.
380.
Okay.
Your lordship, my submission is that the prosecution case is that first the Azhar was lodged, then the investigation was done, after that seizure was done, and the arrest. And the investigating officer in her deposition, she stated the same thing. That first the Azhar was done, then investigation, after that seizure and arrest. But your lordship, if we take the statement of the informant who had lodged the Azhar, that is at page number 50, your lordship. Your lordship may kindly take page 50.
Yes,
I may read, your lordship.
yes.
I am the informant in this case. I know the accused, but I do not know his name. My mobile phone was stolen by someone while I was sleeping in our camp. Our contractor has informed me that a mobile phone is recovered and lying in PS. Accordingly, on their instance, I filed an Azhar. So the informant says that someone informed him that a mobile has been seized by the police. It is the police station. After that, he went and gave the FIR. So the prosecution
How it
cases,
helps you?
prosecution cases, first Azhar was lost, then investigation was done.
Okay.
But here it implies that beforehand something was there and he just went and gave it in Azhar. And based on that, the appellant was arrested.
Okay, how it affects the merit,
Lordship.
how it affects the merit of the case?
No,
That-
Lordship. The thing is that what was the sequence of events? What was the chain of events? Whether Azhar was lost first, whether the mobile phone stolen first, then Azhar, then
So-
investigation.
So is it your submission that whatever has been stated in the Azhar is not true?
Not true, Your Lordship. It is not true. Even the PW1, if we take the statement of PW1, Your Lordship,
No, for this 389 purpose, I just want your crux of your submission.
the crux of my submission,
What is on merit? What is your case?
on merit, Your Lordship, nothing was recovered from me.
Okay.
Even the seizure list, the seizure witness, when the
Okay,
seizure,
no recovery was made by.
no recover was made from me. It is just that I was trapped. I'm an illiterate person. And so I was trapped in this case. Even Your Lordship, the seizure witness on basis of whose evidence he is coming.
From
this-
where the mobile was recovered? From whom the mobile was recovered?
As per the seizure list, the mobile was recovered from my position.
Your possession,
But Your Lordship,
before lodging of the FIR.
that is
No.
not sure, Your Lordship. From the prosecution case, that is not.
But it was from your possession. also.
Position.
It is said that it is from my possession, but it's not true, Your Lordship. And Your Lordship,
Okay, heard. Mr. Firoz Khan, F. Khan,
F. Khan, I am appearing on behalf of F. Khan.
what is your name?
A. Khan.
Heard Mr. A. Khan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 389 of the Code of Criminal Procedure, 1973, has been filed by the applicant, Shri Marna Pegu, praying for suspension of the sentence which was imposed on him by the judgment and order dated 22/12/2023, passed by learned Sessions Judge Majuli in Sessions Case number 29/2023, whereby the appellant was convicted under Section 380 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 10,000 with default stipulation. The said order, judgment and order has been impugned by the applicant in the connected appeal, that is criminal appeal number 81/2024. Stop. Learned counsel for the petitioner has submitted that the learned counsel for the applicant has submitted that the applicant has a good case to pursue in the connected appeal, as he has been trapped in the in this case, and the in this case, stop. It is submitted by learned counsel for the applicant that in this case, the stolen property are 2 mobile handsets which were seized by police even before lodging of the FIR. However, the testimony of PW1 does not corresponds to the sequence of event which appears from the materials on record. It is also submitted that there is a fair chance that the appellant may get a verdict of acquittal in the appeal. And as the sentence imposed on the present appellant is for a limited period of only 3 years, if he is not allowed to go on bail, if the said sentence is not suspended during the pendency of the connected appeal and the appellant is not allowed to go on bail, then in event of ultimately getting a order of acquittal in the pending criminal appeal, he would be greatly prejudiced. Stop. Considering the submissions made by learned counsel, also counsel for the appellant, also considering the fact that the appellant has been convicted for a short period of only 3 years, the execution, the operation of the impugned judgment is hereby suspended during the pendency of the connected criminal appeal, that is criminal appeal number 81/2024, and the appellant is allowed to go on bail of rupees 30,000 with 1 surety of like amount, subject to the satisfaction of learned Sessions Judge Majuli, with following condition that he shall surrender before the learned Session Judge Majuli, if it is required after culmination of the pending appeal, and he shall not indulge in any offense similar to that for which he has been convicted in the instant case by the impugned judgment. With above observation, this interlocutory application is disposed of.
Obliged, your lordship. Obliged, your lordship.
Item 11 order.
May I please your lordship? Lordship, in this case, lordship, notice issued lordship, other side not at their notice already been issued lordship.
No, I have not heard you.
Notice already been issued lordship.
Issued on the respondent.
Respondent number 2 lordship.
So this case is ready for hearing.
Service commission, service commission.
Awarded that yes.
Service commission.
Services.
As per office.
Services,
Awaited.
no, what is your submission? You have taken steps for issuance of notice
Lordship.
on respondents,
Lordship,
respondent number 2. But
Lordship.
whether the notice has been served,
Yes, lordship.
on what
Uh,
basis you are submitting?
Lordship, service is awaited lordship.
It is yet to be served.
Yes, lordship.
Okay. Heard, Miss
P. Polita.
P. Pondita, learned counsel for the petitioner, who submits that though the petitioner has taken steps for service for issuance of notice on the respondent number 2. However, the service report is still awaited. It appears from the office note dated 18/3/2024 that neither AD card nor the unserved notice in respect of respondent number 2 has been received back. What will we do? Will you take fresh steps or
Lordship, issue fresh lordship.
stop? In view of the office note, the petitioner is directed to take fresh steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on at a fixed date. 24 April.
Obliged.
Item 12.
As well, kindly take the IA. This is an IA for condemnation of delay minutes. The delay is of 565 days.
565.
Yes, Milord. Milord, we have taken steps on respondent number 2, who's the informant. However, Milord,
What is the case?
Milord, it's a conviction under 376(1).
376.
For 10 years, Milord. The date of judgment is 2nd of May 2022.
Now,
Milord,
whether notice,
notice was issued, Milord, already, and notice, Milord, on 13th of February 2024, we took steps. Usual process was done on 22nd of February 2024. Unserved notice has not come back. AD has also not come back, Milord. My humble submission, Milord, is that the delay may be condoned. Why I'm saying this, Milord, is because on merits, this is a very good case, Milord. Because what has happened in
no,
this case,
but
Milord,
once notice has been issued,
it has been, Milord. The unserved notice has not come back, Milord. That is my, when it comes to the IA for bail, Milord, we'll ensure, this honorable court will also ensure that the informant is heard. It's only for the delay condonation, Milord, I'm making this humble prayer.
no,
The delay may be condoned.
for delay condonation also, they are to be heard once notice has been issued.
Milord, the
Right.
notice has not come back, Milord. That is my only.
565 days delay, my lord.
Because
Milord,
delay,
My lord, they may
causation.
have some objection, my lord.
This is the
No.
causation, Milord. If Milord will kindly see my IA.
before we go into the,
My lord.
first we have to ensure that respondent number 2 is served with the notice.
My lord, that is.
My lord,
We'll
it has-
direct issuance of fresh notice
My lord.
through jurisdictional police station.
To the police station, my lords. Very well, we'll do that, my lords.
Heard Mr.
A Gautam, my lords. Short
A-
statement.
Heard Mr. A. Gautam, learned counsel for the appellant, learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 29/2/2024, it appears that the notices issued to respondent number 2 through registered post with AD has not returned yet. Now, considering the fact, after stop, considering the fact that the notices sent to the respondent number 2 are who you have mentioned the, how you have sent the notices.
Yes, my lords. Registered post with AD on 13th of February, 2024.
You have mentioned the name,
Yes, my lord. No, not the name, my lords.
then
because
how notice will go?
to the location, my lords.
If you have not mentioned the name of the addressee,
That is the problem, my lords, because we are not supposed to mention the name. It's a rape case. my
then
lords.
no letter will reach its destination ever if you don't name the addressee on the
understand.
letter.
My lords, we had pointed this out in the hearing. However, my lords, because of the privacy concerns, we could not mention the name.
No, but privacy is to be maintained, but you have to also ensure that notices reach
Yes,
out.
yes, certainly, my lords. My lords, now when we do it through the police station, my lords, I'll ensure that, my lords. The name
So
is mentioned.
police have to be also informed about the name.
Yes, yes, indeed, my lords. We are aware of that, my lords. However, my lords, there's the constraint of that privacy issue, my lords. That's the only thing.
No, unless police are to be told that so and so is the
Yes,
victim.
yes. With the policeman, my lords, we'll do that. We'll inform the police.
The stop. The applicant, after stop, the applicant is directed to take fresh steps for issuance of notice on the respondent number 2 to be served through the officer in charge of Moregaon Police Station. The applicant shall submit return of notices along with the copy of condemnation of delay condemnation petition, as well as memo of appeal to the registry, which in turn shall forward the same to the officer in charge of Moregaon Police Station. Stop. On receipt of the said notice, the officer in charge of Moregaon Police Station shall serve the same on the respondent number 2 / victim and submit a service report and submit a report of service of the said notice to this court through the registry on date on 22nd of April.
That's the father's name is there, my lords. I just remembered. Because of the father's name, my lords, they said that it's not necessary. In usual process also. With the victim.
Okay. But now you can take steps.
We'll do that. We'll mention the victim.
List this case accordingly on 22nd of April.
Let's, one more thing, my lords. The LCR had been called for, it has not been received, my lords. It may be indicated.
No, but LCR ought not to
Sir,
have
it's
been
not
called for.
Yes, my lords, but it was
Because
called
we don't know
by the
whether
honorable
if you are calling for the LCR, then this whole exercise is futile.
Yes, my lords.
Then there is a presumption that your delay would be condoned.
Yes. Well, since it was there
There
in the
cannot be
report
any
form.
such presumption.
Yes. It was on the first day it was called for, therefore I thought. it
On
was-
next date, we will,
Yes, very well.
because delay is not yet been condoned.
No, I completely understand. Grateful.
May I please, your lordship, my lord? My lord, the scan copies of the
record was called for has not been received, my lord.
চিঠি বিচাৰিছে নেকি আপুনি?
Not bail application or record.
সেইটো হৈ গ'ল। Scan কৰি
Heard
scan
Mr. N. Mahajan, learned counsel for the petitioner. Who is the respondent? State.
Mine.
Respondent number one is clear, respondent number two is the informant.
Whether notices are served.
Notices were sent, my lord, service report is not there in the office report. Service report is awaited. my lord.
What case is this?
My lord, here in a bail application, my lord, the London Sessions Judge had passed two directions, my lord, to change the IO and to hold a departmental inquiry against the IO, my lord. That order was stayed, my lord, and the case record of the bail application was called for, my lord. Scan copy of the bail application was called.
No, what is the offense? Offense?
Offense was, my lord. T76, my lord, it is not those 1, 3 and postcode.
Okay,
Not-
so victim is not required to be heard.
But we impeded the informant, my lord. We
Informant.
sent notice to the informant.
No notices were sent through which mode?
Notices were sent through, my lord. ADA and usual, my lord. 163, my lord.
Who is respondent number two?
The informant, my lord.
How he is related to
The
the
husband
victim?
of the
Husband of the victim.
victim, my lord.
Okay. Heard Mr. N. Mahajan, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. It appears from record that the notices issued to respondent number two has not yet been served and service report is awaited. It also appears that the scanned copy of the case record of bail application number 7/2024, which was called for from the Court of Learned Session Judge Karbi Anglong, has not yet been received. Issue reminder for call for the scan copy. The registry to issue reminder fixing 25th April for fixing 25th April 2024. What will happen regarding the respondent number two? We'll await.
We'll await, my lord.
Okay. Await service report as regards respondent number two.
And the interim may continue, my lord. The observations were stayed, my lord.
Okay, the interim order shall continue till next date.
Obliged, my lord. Highly obliged.
Item 45 for supplementary.
What?
Lordship, I may be considered lordship after receipt of the LCR lordship. Lordship, only going through the judgment lordship. All the materials are not available in the judgment lordship.
Yeah, I will place from the lordship judgment itself that apparent from, it is apparent from the judgment itself that no ingredients is there under section 304D. I will not place any disputed fact, and even though I have the record, I have to your lordship, that submission
but
she
it
can
is-
verify from the record also.
First, you listen to his submission. If after hearing his submission, if you feel that trial court records are necessary,
Yes.
then we'll go for it.
Yes,
He's saying that he will rely only on judgment.
judgment. I will not place any disputed fact.
If we feel that the perusal of record is necessary, then we'll call for record.
Yes, lordship, without perusing the record, lordship.
No,
it will be
he is saying
difficult.
that he will not go into records.
Yes.
Let us hear him, then try to respond to his submission. Yes.
Page 29, lordship, may I say here, just before going to that part, just I am
No,
placing
this-
the brief
this-
fact here.
What are the facts?
Brief facts. Here lordship, the deceased and the appellant number one, Johar Ali Sheikh, they were married before 4 months of the alleged
How
incident.
many appellants are there?
Three appellants.
Three appellants.
Three appellants.
Appellant one is the husband,
Husband and in-laws of the deceased.
mother-in-law and
Father-in-law and
father-in-law.
mother-in-law.
Okay.
They are before your lordship. So before 4 months of the alleged incident, they married without informing the relatives of the deceased girl. Lordship. They eloped and got married.
Okay.
And after 4 months, she committed suicide. That is admitted fact.
Suicide.
Suicide. So that is admitted.
Okay. When was the marriage?
75.
When they eloped?
They eloped, lordship, 4 months prior to the alleged incident.
Okay. No fixed date is there.
No fixed date. And date of offense is 7/8/2022.
7/8/2022,
8/2022.
on which she committed suicide.
Lordship. And now I am taking your lordship to page 16 of the impugned judgment. Page 16, internal page 4 of the judgment.
Yes.
Page 16, paragraph 4, lordship may kindly see. On the appearance of accused number 1, accused number 2, and accused number 3, and upon hearing both sides, charges under section 304B, 498A, 34 IPC were framed against them, to which they pleaded not guilty and claimed right. So why I am placing for your lordship this lordship may kindly see that there is no charges under section any of the provisions of Dowry Prohibition Act. Because of that, I am showing this paragraph to your lordship. Now, lordship may kindly turn to page 29 of the impugned judgment.
You have the copy of judgment.
Lordship, it's different from Lordship. The subject matter is different here, Lordship. I have, I'm going through Jafar Ali, criminal appeal number 75, Lordship.
Who has provided you that copy?
Their office.
Office-
Probably because of
office
same
lodge.
name. Our is Johar Ali Sheikh and their file is Johar Ali.
Jafar Ali, Lordship.
You provide a copy.
Yes, I have
Because-
given her the copy of judgment. I have.
It will record, man.
No, it's not.
You take Johar Ali and keep Jafar Ali.
I received Jafar Ali, Lordship.
No, keep that aside.
Lordship.
And listen to his submissions. If you feel that you need some time, I will give you time, but you may not need after hearing his submission.
Lordship.
Yes.
Page 29, lordship may kindly see.
Yes.
Page 29, paragraph 37, I am reading, lordship. In the present case, therefore, the demand for cash for purchasing a car would definitely fall within the definition of dowry in view of the expensive meaning of dowry. So this is disputed. I am not going into that dispute. As I have already submitted, I will not go into dispute. Because in the FIR itself, your lordship will find that it is not a luxury car. It is a lordship a business vehicle for business purpose. In the FIR itself, it is mentioned. And if it is for business purpose, it will certainly not come under Dowry Prohibition Act. So I am not going into that aspect, lordship. Just I am reading further. The next aspect would be to define harassment. The word harassment, I believe, has been used in its common dictionary meaning, whereby a wife is continuously tormented with demands of dowry, irrespective of the fact whether such unlawful demand is accompanied by any physical torture. A behavior which annoys someone can be said to be harassment if such behavior is persistent. The harasser may be mild in his approach, but in the demand per se is unlawful. It is likely to annoy and therefore constitute harassment. Since seen from its perspective, if the accused continues with his demands of article, even though it can be shown that such demands were not accompanied by any physical torture, harassment for dowry would be made out. Just here, what my understanding after reading this paragraph is, he has demanded dowry, therefore it was treated to be that she was harassed by the accused person. But in my humble understanding, Lordship, and what I have found from on judgment of Honorable Apex Court, there in dowry death cases, there has to be torture or harassment in connection with demand. So these are two different elements. That harassment and dowry demand, these are two different elements. It cannot be said that dowry demand is there and therefore she was harassed. So just to elaborate on this aspect, Lordship, just I am relying on a citation, Lordship. Paragraph 10, Lordship, may I kindly see of the
No,
judgment.
before that, read section 304B.
Yes.
Okay. Right.
Dowry death. Where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment. Now, Lordship, may I kindly see, subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand of dowry. So these are two different elements.
Okay, for or in,
Yes.
for or in connection with. So,
But in the impugned judgment which I have placed before your Lordship, the trial court hold that although there was demand, so there was harassment. Although there is no ingredients of harassment was there. And now I am taking your Lordship to page 33. Last paragraph, Lordship, I am reading paragraph 45
of
the impugned judgment, Lordship, of my appeal memo. Page 33, paragraph 45 of the impugned judgment.
paragraph 45.
Lordship.
Yes,
In the present case, Lordship,
yes.
in the present case, the evidence of PW5 Hasina Bibi is crucial in the context of this case. She categorically deposed about receiving a phone call from her daughter that she is being tortured for ₹2 lakhs for purchase of a vehicle. She also deposed that she had immediately visited the residence of PW6 and 7. PW6 and 7 both appeared as prosecution witnesses, and both of them deposed that PW5 had visited their residence. It is argued in this context by the learned defense counsel that the prosecution should have submitted the call detail records of the phone of PW5 to prove that phone calls were made. However, I believe such an argument does not hold water in view of the direct oral evidence of PW5 that she had received a phone call from the deceased. The evidence of the PW5 was subjected to thorough cross-examination by the defense, And as discussed herein, there is an onus placed on the accused person under section 8A of the Dowry Prohibition Act to probabilize that no such demand was made. So now 8A has been taken into consideration by the learned trial court. So I am just again taking your lordship to section 304B. Section 304B.
Yes.
Explanation part, lordship may kindly see. For the purpose of this subsection, dowry shall have same meaning as in section 2 of the Dowry Prohibition Act. So the intention of the legislature is clear that only the definition of dowry prohibition that will be applicable in 304B. They have not said that the presumption available under Dowry Prohibition Act that will be applicable in 304B. So that cannot be applied here, lordship. So the prosecution have to prove with certainty that yes, dowry was demanded, and in connection with that, torture has been there, and therefore she has died an unnatural death. So they have to prove that aspect. So accordingly, they were convicted under section 304B for 7 years, lordship. And my humble submission, just I have, as I have placed to lordship that judgment, just I am again placing that Honorable Apex Court judgment which I have given lordship 2015 5 SCC. Paragraph 10, lordship may kindly see for a moment.
No, the presumption in section 8A of the Dowry Provision Act was taken recourse to by the trial court only to come to a conclusion that the appellants failed to show that no demand was made.
Yes, because as I have already submitted, I will not go into disputed fact, but as your lordship has pointed out, put a query, lordship, so I have to answer it.
No, with the help of this presumption under 8A,
Yes.
to
Because
what
lordship,
conclusion court came?
because lordship, the PW5 is the only witness who said that
Who is
prior
the
to
mother?
her death, yes,
PW5 is the mother.
mother of the victim. She said that prior to the death, on the previous night of her death, she called me over telephone and informed that she was tortured for demand of dowry. And the defense put categorically, lordship, a question that what was the number of the phone number? Did you inform the police about this phone number? She said no, because it is on record also that the victim had no phone of her own. So there was no question of informing the PW5 over telephone, lordship. So therefore, that about CDR, that cross questions were there. The defense case was that she was never contacted by the defense. The deceased never contacted PW5.
Now, whether trial court relied upon the PW5's deposition?
Yes, only on the basis of PW5 I was convicted.
So what is the wrong?
She deposed before the court. I have the certified copy if your lordship.
In judgment, para 19, para 14, PW5 lordship.
PW5 lordship.
Photo diya sir.
Direct deposition to server.
She deposed that in the month of August, her daughter called her at about 9:30 PM and started crying.
No,
She informed that
I'm not going into details of facts.
Lordship.
PW5 says implicated you that there was a demand and cruelty on her daughter.
Lordship.
Trial court said that trial court relied upon the testimony of PW5
Yes.
and also said that the appellant failed to give any evidence
Lordship.
to discard the testimony of PW5.
My burden will shift only if they show that there are charges. Just the lordship may kindly take up the Dowry Prohibition Act, the section 8A I am reading
No,
because section
no,
8A
my
says,
query is not complete.
lordship.
By taking recourse to 8A of the Dowry Prohibition Act, what help the trial court took
Because
in
that
arriving at the conclusion?
there was a dispute regarding whether
Because
dowry-
if 8A was, even if 8A was not taken recourse to,
Right.
PW5's evidence was there,
Lordship.
which trial court has relied on.
Lordship.
Now your submission may be that PW5 was not reliable
Yes,
evidence,
yes,
reliable witness.
lordship.
But if we discard that portion, that 8A,
Lordship.
taking presumption under Dowry Prohibition Act,
Lordship.
still there is some material against you. PW5's evidence is there.
No, then lordship that first I have placed before lordship that harassment is not there. Because they have to fulfill all the ingredients. Just I will place that
No,
judgment before lordship.
but the daughters told her mother over telephone that I am harassed for demand of dowry, both.
No, that part lordship may kindly see. PW5 of the judgment just I am placing again before lordship. Page. Page 19. Page 19 lordship may kindly see.
There are 40.
Page 19 of the
Of
judgment.
the impugned judgment of my appeal memo lordship.
Yes,
Paragraph 14 lordship may kindly see. PW5.
yes.
Hasina Bibi is the mother of the deceased. She deposed that even though she was reluctant to arrange the marriage between A1 and her daughter eloped with A1 and married. Later, they accepted their marriage and arranged a social function in which they gifted articles worth ₹60,000. After a few months of marriage, accused started harassing her daughter for an amount of ₹2 lakhs. She deposed that in the last month of August, her daughter called her at about 9:30 p.m. and started crying. She informed that she has been beaten up by all the accused and she started requesting for money. Regarding this beating up logic, medical report not supported. Therefore, the harassment part was taken by the trial court in connection with demand of dowry. That medical report negated that aspect because he said on the previous night she was beaten, but medical report is silent on that aspect. She immediately went to the residence of VDP Secretary Abu Daud. Thereafter, she went to the residence of Azhar. And he said that he will go in the morning. On the following morning at about 9 a.m., she heard that her daughter has died. So this is her evidence. And in the cross-examination also, she was put a specific question whether the lordship she remembers that phone number or that CDR was called. That is question was put to the investigating officer lordship. Because it is the duty of the prosecution to prove each and every ingredient beyond reasonable doubt. When first part is not there, that beating part, and therefore a phone call was regarding phone call, those questions were asked.
Okay.
And therefore, lordship, had there been any medical injury or medical report supporting the medical report, the trial court would not have lordship given these findings at paragraph 38, page 29, regarding harassment, which I have placed before your lordship.
Paragraph?
Paragraph 38, page 29. That demand of dowry amounts to harassment, that findings. That findings is not required at all.
And your submission is demand of dowry in itself is not an harassment.
Yes. Because lordship, just I am placing that judgment, I have given lordship 2015, 5 SCC.
2015 5 SCC.
5 SCC paragraph, lordship may take paragraph 10. Time and again, Honorable Apex Court said that these 5 ingredients are required. paragraph 10. Lordship, got it?
Yes.
To sustain the conviction under section 304B IPC, the following essential ingredients are to be established. Number one, the death of a woman should be caused by burn or bodily injury or otherwise than under a normal circumstance. It is present in our case. Such a death should have occurred within 7 years of her marriage. That is also there. She must have been subjected to cruelty or harassment by her husband or any relative of her husband. So that is absent. Such cruelty or harassment should be for or in connection with dowry, demand of dowry. So this shows that this harassment and dowry demand, these are two different aspects. There has to be torture or harassment in
Okay,
connection with
we'll
dowry.
continue after lunch. You have to show that demand of dowry in itself is not cruelty. Demand of dowry in itself is not harassment.
Lots. That.
Add two.
Second of it.
You have to give a mention memo. Okay, allowed.
Because there is 21, it's written, but deep level. 2nd of April. With your lordship, the judicial order, that date is fixed for 28. That's why I.
No, now, in view of the mention. it is-
One item, my manager has informed me that I appear for the respondent. But actually, it escaped my notice.
Appeal against Secretary Lords.
When it is fixed,
Today is listed at item number 38.
38.
Lords.
So what is the prayer?
My learned
You
friend
are not
Secretary-
ready.
I actually did escape my notice,
Okay.
an old case, my lord. Could it come up after verification, my lord? I have to reconstruct the file
Any
also, my lord.
objection?
I'm not.
Heard Mr. S. K. Learned counsel for the appellant, also heard Mr. D. Das, learned additional public prosecutor.
No, Lordship. he is
I
appearing-
am as
It's a
privately,
private-
Okay,
private responsible.
Mr. D.
respondent
Das,
number one.
learned counsel for the respondent number,
One.
respondent number 1. Learned counsel for the respondent has prayed for some accommodation as he is not prepared today. Considering the submission, the prayer is allowed. Let this matter be listed
After-
after
after
2
the-
weeks. After
the
two
votes.
2
Much.
weeks.
Obliged.
Much.
So Lordship, just again referring to that SCC 2015-5,
Yes.
paragraph 10, Lordship. That ingredients of section 304B. Why I'm placing that in next judgment which I will place, in absence of harassment, that conviction was set aside. So harassment is required. So that I'm placing, Lordship. Paragraph 10, Lordship, may I see? To sustain the conviction under section 304B IPC, the following essential ingredients are to be established. One, death of a woman should be caused by burn or bodily injury or otherwise under normal circumstances. Such a death should have occurred within 7 years of her marriage. She must have been subjected to cruelty or harassment by her husband or any relative of her husband. Four, should be for or in connection with demand of dowry. So these are two different logic. And fifth, such cruelty or harassment is shown to have been meted out to the woman soon before her death. So these 5 ingredients are required. Now, why I'm saying that harassment is different from demanding dowry, just I'm relying on another judgment of Honorable Apex Court, okay? That is decided on 20th April 2023. Your lordship will find paragraph 21 and 23. Paragraph 21.
Paragraph 20. Yes.
In the aforesaid evidence laid by the prosecution, none of the witnesses stated about the cruelty or harassment to the deceased by the appellant or any of his family members on account of demand of dowry soon before the death or otherwise. Rather, harassment has not been narrated by anyone. It is only certain oral averments regarding demand of motorcycle and land, which is also much prior to the incident. The aforesaid evidence laid by the prosecution does not fulfill the prerequisite to invoke presumption under section 304B IPC or section 113 of B of Indian Evidence Act. Even the ingredients of section 498A IPC are not made out for the same reason, as there is no evidence of cruelty and harassment to the deceased soon before her death. And now paragraph 23, Lordship may kindly see. On a collective appreciation of the evidence laid by the prosecution, we are of the considered view that the prerequisite to raise presumption under section 304B IPC and section 113B of the Indian Evidence Act having not been fulfilled, the conviction of the appellant cannot be justified. Mere death of the deceased being unnatural in the matrimonial home within 7 years of marriage will not be sufficient to convict the accused under section 304B and 498 IPC. The cause of death as such is not known. So what I'm placing for lot is that harassment and cruelty, this is too different from demanding dowry, and that has to be established beyond reasonable doubt. In the present case, the learned trial court observed that there was demand of dowry, so it is presumed that there was harassment. That cannot be there. It has to be independently, it has to be there. And my second limb of submission before your lordship is that here the conviction is for 7 years.
Yes.
My second limb of submission is that here conviction is for 7 years, which is short-term sentence, lordship. So if they are allowed to remain on jail, that subsequently it will.
On what basis you are saying that?
That Kiran Kumar judgment I am having, lordship.
7 years is held to be short term.
Short term.
7 years.
Yes, 7 years it was held to be short term. Kiran Kumar. In paragraph 8, your lordship quoted that Kiran Kumar judgment, lordship.
No, whether Kiran Kumar says so.
Yes, paragraph 8, it is there. Kiran Kumar's case was under section 376 and punishment was for 7 years.
Where is Kiran Kumar?
That I'm sorry, that judgment I had misplaced, but I can place before. Conviction was for 7 years and under section 376. Just I'm giving.
Okay. Yes.
And during trial or during investigation also, they were in custody for 5 months, 4 days. That your lordship will find at page 14 of my appeal memo.
When the judgment was passed?
This judgment was passed on 20 February 2024. Earlier 5 months, now about 1 month. Near about 6 months they are in custody. Out of 7 years.
Yes, yes, yes.
Lordship, as per the reposition of PW 5, Lordship. She informed that she has been beaten up by all the accused and she stated requesting her for money, lordship. So demand of money and harassment is there, lordship. And within 4 years of marriage, she died, lordship. 4 months. Four months, lordship. Sorry, lordship, within 4 months of marriage, she died, lordship. As lordship, I could not go through the record because LCR is not here, so I have some.
Whether, what is the report in, what postmortem report says?
Suicide.
Now, whether this beating has been, there is any corroboration
PW 10.
page?
PW 10, okay, just checking that.
Your submission is that the beating has not been corroborated by the medical evidence. That is your submission.
In PW 10 lordship medical officer, a small bite mark present at the right side of neck. Bite mark present at the right side of neck. Lordship, only repeatedly LCR is not here, lordship.
We are disclosing. Heard Mr. A. Ahmed, learned counsel for the applicants. Also heard Ms. N. Raj, learned additional public prosecutor. This application under section 389 of the Code of Criminal Procedure, 1973 has been preferred by the present applicants who are the appellants in the connected appeal, which has been registered as criminal appeal number 75/2024. So in this interlocutory application, the applicant have prayed for suspension of the sentence imposed on the present applicants by the judgment and order dated 20/2/2024 passed by learned Sessions Judge Kajalgaon in Sessions Case number 41/2022, whereby all the three applicants, namely Johar Ali Sheikh, alias Johar Ali Sheikh, alias number 2, Jail Haq Ali, and Salema Bibi, are convicted under section 304B of the Indian Penal Code and are sentenced and have been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000 each, and in default of payment of fine to undergo rigorous imprisonment for 1 year. The aforesaid stop. Learned counsel for the petitioner has submitted that on the basis of an FIR lodged by one Sekandar Ali, the brother of the deceased Jasmina Khatun, on 7/8/2022 before the officer in charge of Basugaon Police Station, Basugaon PS case number 646/2022 was registered under section 498A/304B of the Indian Penal Code. Stop. And Indian Penal Code, and investigation was initiated. Stop. Ultimately, after completion of the investigation, charge sheet was laid against the above named applicants under section 304B under section 304B of the Indian Penal Code. The applicants faced trial before the Court of Learned Sessions Judge Sirang Baksa, wherein charges under section 304B/498A/34 were framed against the above named applicants, and when the said charges were read over and explained to them, they pleaded not guilty and claimed to be tried. The prosecution side examined 14 numbers of witnesses and to bring home the charges against the present applicants. Stop. All the applicants were examined under section 313 CRPC. However, during 313 of the Code of Criminal Procedure, during which they pleaded their innocence and denied the truthfulness of the testimony of prosecution witnesses. However, they declined to adduce any evidence in defense. Ultimately, by the judgment and order which has been impugned in the connected appeal, the applicants were convicted and sentenced in the manner as already described herein above. Learned counsel for the applicants has submitted that in the instant case, the ingredients of offense under section 304B were not proved, and the trial court had erred in coming to the conclusion of finding of guilt under section 304B/498A against the present applicants on the basis of the testimony of PW5, as well as on the basis of the presumption which the trial court had drawn under section, where is this?
8A.
Under section 8 of the
8 capital A.
8 capital A.
Page
Where is the
25.
relevant paragraph in the judgment?
Page 25, paragraph 29. Page 25, paragraph 29.
Capital A.
Twenty-nine 30
of the which act?
of Dowry Prohibition Act.
Of the Dowry Prohibition Act, 1961. It is submitted by learned counsel for the applicants that no charges were framed against any provision of Dowry Prohibition Act 1961 against the present applicants, and therefore the trial court was wrong in taking recourse to the provision under section 8A of the said act in coming to the finding of guilt of the present applicants. It is submitted by learned counsel for the applicants that the only section 2 of the Dowry Prohibition Act can be taken recourse to in an offense under section 304B of the Indian Penal Code due to the as same has been incorporated in the explanation to section 304B of the Indian Penal Code. Stop. Learned counsel for the petitioner has also submitted that the for coming to a finding of conviction under section 304B of the Indian Penal Code, following essential ingredients are to be established. Quote para 1, 2, 3, 4, 5 from para 10 of the judgment in 2015 5 SCC 201. Learned counsel for the petitioner applicant has also submitted that that mere demand of dowry is not sufficient to convict a person under section 304B of the IPC, as in addition to the demand of dowry, the victim must be subjected to cruelty or harassment for or in connection with demand of dowry. However, in this case, it is, however, it is submitted that in the instant case, learned trial court has, in which paragraph it said that?
Page 29, paragraph 38.
Page 29, paragraph
38. Last paragraph, Lordship, page 29 of appeal memo.
Yeah, line, yes. Last one. As in the impugned judgment, implied existence of harassment only on the ground that there was a demand for dowry, and in absence of any proof of cruelty or harassment meted on the victim, the trial court came to the conclusion that there was harassment and physical torture on the victim woman. Stop. In support of above submissions, learned counsel for the applicant has cited a judgment of the Apex Court of India in Charan Singh alias Charanjit Singh versus State of Uttarakhand, reported in 2023 Live Law SC 341, wherein it was observed as follows. Quote paragraph number 21 from the judgment. 21
And 23.
and 23 from the judgment. Stop. Learned counsel for the petitioner has also submitted that the learned counsel for the applicants has also submitted that the applicants have a fair case to argue in the connected appeal, and they have a fair chance of getting a verdict of acquittal in the connected appeal. And as the applicants are sentenced to a short period of 7 years only, they should be allowed to go on bail after suspension of the sentence imposed on them during the pendency of the connected appeal. In support of submissions, in support of submissions, in support of said submission, learned counsel for the applicant has cited a ruling of the Supreme Court of India in the case of Kiran Kumar versus State of MP, reported in
2001, volume 9.
9 SCC 211, wherein it was observed as follows. Quote, quote paragraph number 3 from Kiran Kumar. Judgment. Stop. On the other hand, learned additional public prosecutor has one more line before that. Learned counsel for the petitioner has also submitted that though PW5, who is the mother of the deceased, had deposed that the deceased was subjected to cruelty and was beaten up before her death. However, it is submitted that the post-mortem report falsifies the testimony of PW5 in this regard, as no injury has been found on the no injury and sign of beating has been found on the body of the deceased. Stop. On the other hand, learned additional public prosecutor, Ms. N. Das, has vehemently opposed the grant of bail to the applicants and suspension of the sentence imposed on them during the pendency of the connected criminal appeal. She has submitted that the testimony of PW5 is very categorical to the effect that the present appellants had subjected the daughter of the PW5 to cruelty and harassment for dowry, and she was also beaten up by them before her death. It is also submitted that where was the bite mark?
On the nail polish.
It is also submitted by learned additional public prosecutor that post-mortem report also shows that the deceased had bite mark
Bite mark.
on which side of the neck?
Neck, Lordship. PW10.
On her neck. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the judgment cited by the counsel for the parties.
Right side of neck. Lordship.
Right side of the. It appears that, no, not it appears. At the stage of consideration of an application under section 389 of the Code of Criminal Procedure, the court is not supposed to delve in detail in and consider the evidence on record. However, it appears that though the case of the prosecution side is mainly based on the testimony of PW5, the trial court had taken recourse to invoking the provision of section 8A of the Dowry Prohibition Act 1961 for drawing a presumption against the present applicants when clearly there was no when no charge was framed against the applicants under the provision of Dowry Prohibition Act 1961. It also appears that the submission made by learned counsel for the petitioner that the prosecution side has to prove, in addition to demand of dowry, to prove separately the component of cruelty and harassment in addition to demand of dowry, which according to learned counsel for the petitioner applicants has not been done in the instant case. Considering the submissions made by learned counsel for the appellant, it appears that the appellants has a fair arguable case in the connected appeal. And if the execution of the sentence against the present applicants is not stayed during the pendency of the connected appeal, in the event of any acquittal in the connected appeal, they would be highly prejudiced. No, a line to correction. No, from the beginning. State during the pendency of the connected appeal, they would suffer great prejudice. Stop. Moreover, the ruling cited by learned counsel for the applicant in Kiran Kumar versus State of MP within bracket Supra shows that when a person is convicted and sentenced to a short-term imprisonment, the normal rule is that when the appeal is pending, the sentence should be sentence should be suspended, and the rejection is only by way of an exception. Stop. In the instant case, no such exceptional cause to reject the prayer for suspension of sentence could be shown by the prosecution side. Stop. In view of aforesaid reasons, the application is allowed and the sentence and the operation of sentence imposed on the above named applicants is hereby suspended during the pendency of the criminal appeal number 75/2024. The applicants, above named applicants are also allowed to go on bail of rupees 30,000 each with one surety of like amount to the satisfaction of learned session judge
Sriram, that's
Sirar
Kandalgaon.
during the pendency of the connected appeal, that is criminal appeal number 75/2024. With above observation, this interlocutory application is hereby disposed.
Only one prayer, so that Sessions case number 41 of 2022, that may be mentioned.
No. Last para case. Wherein the judgment which has been passed in sessions case number 41/2022 has been impugned. What will happen to main case?
That is, your lordship has already
NCR,
directed to,
no, NCR.
already directed to be listed after 3 weeks, 4 weeks.
In main case, heard Mr. A. Ahmed, learned counsel for the petition, appellants, also heard Ms. N. Das, learned additional public prosecutor. The notice to respondent, you have taken steps.
Today I will take lordship.
You have to take steps.
Yes,
Otherwise, your 389 will be vacated.
Yes, lordship. Today, by today I will take.
Notice to respondent, the learned counsel for the appellant has submitted that he may be given some more time to take steps for issuance of notice on respondent number 2. The prayer is allowed. It also appears that the trial court records have not arrived. Issue reminder for the same. List this matter after 3 weeks.
Only thing is that I have to take steps to register court. Because of that, I could not take a stat. Today I will take stat.
No, that was mentioned in the last order.
But that was not online, because my clerk could not verify it.
Okay,
For that reason.
take steps. Take steps through registered post with AD.
Public.
Itu ভিতর দি।
Here, your lordship order is at page 7, lordship, that I have come for modification of the condition, lordship. Here, your lordship has granted bail to two petitioners, lordship, that Mohammed Rizwan and Irfan. Khan. Both are brothers, lordship. And your lordship put condition at page 12, your lordship will find paragraph 17. Each with two securities of like amount, one of whom should be a government servant. And they have submitted their bail bonds, lordship. Accordingly, one of government servant they have found, because they hailed from also another state. They found one government employee, and one of the applicant, that is Rizwan, he was out on bail. But as the Irfan Khan could not find another bailer, lordship, government servant, he could not submit. So my prayer before lordship is that the person who stood as a bailer in favor for Mohammed Rizwan, lordship, may be allowed to stand as a bailer in connection with Irfan Khan, lordship.
No, is there any bar?
That
Whether the condition puts.
because your lordship has mentioned as each, so trial court is insisting for two bailers. So that part, each word may be deleted.
Where is the condition?
Page 7, page 12, paragraph 17, second line, that you will find.
The petitioner shall not be. Read the condition.
The paragraph 17, in view of the above named petitioners are allowed to go on bail of rupees so each with two securities of like amount, one of whom should be a government servant and residing within the state of Assam. Two securities each, and one of them should be government servant. And now trial court is asking for two government servant, one for each petition applicant.
That is not the condition.
But because of that, lordship, he could not file. So only that aspect may be clarified and lordship may dispose of.
No, what clarification is required now? Now, what clarification do
That,
you?
that I have submitted to modify to that extent, and that is not required.
Heard, yes. Ms. Das. Anything? Do you have any submission? In this, the copy has been furnished to them.
Yes, copy was furnished.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This interlocutory application has been filed by the petitioner Irfan Khan in connection with bail application number 3774/2023. Stop. Which modification you are seeking? Where is the?
Page 12, paragraph 17, lordship.
No, in your interlocutory application.
Paragraph just
Para?
Paragraph 4, lordship, may NDC. And 4 and 5.
No, now trial court is insisting on two separate government survey.
Two separate governments.
But that separate word has not been used in the order.
Lordship may observe that because of that I have paid, and your lordship may.
Learned counsel for the petitioner has applicant has prayed for modification of the conditions of bail which was imposed while granting bail to the present applicant by order dated 18/1/2024, passed in bail application number 3774/2023. It is submitted by learned counsel for the applicant that though this court was pleased to direct the applicants to direct the applicant to go on bail of rupees now only one has come.
Lordship, now Irfan Khan has come.
Direct the applicant to go on bail along with the other co-accused on furnishing a bond of rupees 1 lakh each with 2 sureties of like amount, and one of whom should be a government servant residing in the state of Assam. Stop, comma, it is however, the co-accused, namely Muhammad Rizwan, who had submitted the bail bonds and also furnished the one government surety, was allowed to be released on bail by the trial court. However, the trial court is insisting on a separate government servant for the present applicant, and therefore it is prayed that the condition of bail may be modified. Stop. On perusal of the order dated 18/1/2024, passed in bail application number 3774/23, it appears that by the said order, the present applicant was allowed to go on bail along with one another co-accused, and on furnishing a bail bond of rupees 1 lakh each with 2 sureties of like amount, and it was stipulated that one of the sureties should be government servant residing within state of Assam. There is no mention in the said order that each of the accused persons who were granted bail, that both the accused persons who were granted bail shall have to procure separate government servant as their bailer. Stop. It appears that the trial court is not correct in insisting two separate government servant for each of the accused persons who were granted bail when no such mention is there in the bail order. Stop. In view of the above clarification, this court is of considered opinion that no modification is required in the bail order passed on 18/1/2024 in bail application number 3774/2023. With above observation, this interlocutory application is hereby disposed. Yes, what is this?
May it please you, my lord. I am for petitioner. And he is the petitioner's prayer that your lordship, more lordship, that pending disposal of the criminal revision petition.
We are taking up the interlocutory application.
Yes.
272. Okay. What prayer is made in this?
Or
application?
staying of
Saying
the
what?
order of family courts, my lord. Because we moved the criminal division petition 35 to 2024. The impugned order of the family court may kindly be stayed. That is our prayer. Because the petition was moved on 6th October 2024. While the petition was admitted and LCR has been called for from the lower court below, somehow the stay of the impugned order remained unattended. Consequently, the family court went ahead, which
This interlocutory application is in connection with the criminal revision petition.
yes,
In this revision petition, what is the prayer? What have you impugned in this revision petition?
in that division petition was challenged the order of the family court passed under section 125.
125.
Yes, my lord,
Okay.
of the CRPC.
Granting maintenance.
Yes, along with the stay of that order. That was a prayer.
Okay.
The petition was admitted and LCR was called for within a 4 weeks time, and it is now 6 weeks, and yet the records have not yet been transmitted from the lower court to the high court. Anyhow,
Your husband.
I am for the husband, my lord.
And maintenance is given to the wife.
Maintenance giving to wife.
Wife.
Right.
The marriage is still subsisting.
Marriage is not subsisting, my lord.
You are
Marriage has been
divorced.
Marriage has been dissolved.
Okay, you have not challenged that dissolution.
No,
Nobody
we have
has challenged.
challenged that. And we have obtained the decree of dissolution of the marriage.
That
Marriage-
has not been challenged.
He has not challenged the dissolution of the marriage. What he has challenged is the permanent alimony, which
No,
was
we have
granted
chal-
along with the decree of divorce. The permanent alimony, which was granted to the respondent herein, has been challenged by my learned friend by way of a matrimonial appeal separately, Your Lordships.
Not 125.
125 is this application today. 125 is a separate application because there were two separate proceedings going on before the Honorable Family Court. And the permanent alimony is a separate thing. Now, this application was pending for quite some time.
No.
And
Let me understand.
Your Lordship.
This criminal petition, criminal revision petition has been filed by the husband.
Husband.
Challenging the
maintenance which was granted
125.
in 125, which was
and
granted under.
divorce and alimony is pending somewhere
Yep.
else.
Here in this honorable court, he has challenged by way of a matrimonial appeal, not
tagged
the
with
divorce,
this-
not the
tagged
divorce.
with this matter. It
This
is
matter,
before,
Your Lordships. No,
Formal-
it's not tagged with this matter today, Your Lordship.
it is pending
It is
before some
pending
other bench,
before some other bench.
division
Your-
bench.
Yes, Your Lordship.
Because it is
It's a
a
matrimonial appeal.
matrimonial.
Correct.
appeal. Okay. Now what is
It
your?
is, the order has been annexed by my learned friend in the IA as annexure A, page 9. If Your Lordship would like to peruse that. Matrimonial appeal 2 of 2024.
Okay, let him submit.
Lordships.
My lord.
N-
Now,
Today we are hearing the
we are hearing the state
petition,
Stay petition.
stay petition.
I'm objecting to the stay petition.
Okay. Yes, Mr.
The petitioner husband has already paid 5 lakhs of rupees as part payment of the alimony on 4th of March 2024 under section 25 of the Hindu Marriage Act. The petitioner also paying at the moment rupees 2,000 rupees a month as interim maintenance allowance under section 24 of Hindu Marriage Act. The section
Now this 125 proceeding is pending or disposed of?
Disposed.
Only execution is pending.
execution is paid.
Execution is pending. You have not moved any application under 127 for altering in view of the permanent alimony petition.
My lord, we have challenged the very order under section 28. We have challenged the order of the quantum of alimony that has been.
No, that is separate. the divorce decree as well as permanent alimony is under challenge in a separate proceeding. That I have understood. Now,
This divorce has not been challenged, my lord.
only permanent alimony is
Yes,
under
but
challenge
quantum of the alimony has been challenged
by you,
by the husband
by the husband.
and in the High Court.
And that
then
proceeding
pending.
is pending
That
before
proceeding
the
pending,
division
right.
bench of
Yes.
this court.
That
The
provision,
division bench of this.
yes.
And in this case, 125 proceeding is disposed of, execution is going on.
Execution is
And you
going
have
to take,
challenged,
execution is going to take place soon. Today was the date of execution also. But we have challenged the,
in revision petition, what is under challenge?
in the revision petition, both were under challenge. The quantum of the maintenance as granted, as well as prayer was for stay of the execution procedure. But then somehow the stay was not attended to, and records were called for within 4 weeks' time, and more than 4 weeks have elapsed. Had the record come, we could have moved that. But records have not been transmitted to the lower court, the higher court, despite 6 weeks have elapsed by now.
Okay.
Because our division petition will be of little avail if it is not being, if the proceeding is not stayed in the family court matter. Because there are a lot of, the order as passed by the family court, erroneous in law.
Let me take one more minute. The revision petition, in the revision petition, what is under challenge?
Lordships, if your lordship will take up the criminal revision petition, it is annexure 17, page 123 in the criminal revision petition. That is the order which has been, the judgment which has been passed by the learned family court. Annexure 17, page 123. That is the order under challenge in the criminal revision petition. Lordships, if I may just clarify for a moment, what has happened is, your lordship, these were two separate proceedings which were going on before the Honorable Family Court. In the case of 125, the proceeding under section 125 of the CRPC, the Honorable the Learned Family Court has held that he will be liable to pay an amount of rupees 10,000 per month from the date on which we had filed this application. This is in view of the judgment of the Honorable Apex Court in Rajneesh versus Neha, and has said that this quantum of 10,000 will continue only till such time that he pays me the permanent alimony.
Divorce case.
In the divorce case. The moment he pays me that 20 lakhs, that will stop. That will stop. So in my respectful submission, that was a very judicious order. In any case, my learned friend has challenged the matrimonial appeal, by way of the matrimonial appeal, the permanent alimony order as well. Now, in that proceeding, what has happened is that the Honorable Division Bench has issued notice in the matter, naturally, and has admitted the appeal, has called for the records, and in the meanwhile, had granted him 5 weeks time to pay up 1/3 of the alimony, which is 7 lakhs. He has not, the 5 weeks have elapsed. He has not paid 7 lakhs. He has paid only 5. And he's now also praying a stay in this matter. Whereas
in this matter, the condition was this payment would continue till
the permanent alimony. I can understand
20 lakhs.
20 lakhs, your lordship.
Okay, now what is your now?
Now, my lord.
And that 5 lakh
and
has
that-
also been
that-
paid to me. If I may
No.
just one more moment, your lordship. That 5 lakhs has also been paid to me only pursuant to the fact that I have filed the execution petition before the Honorable Family Court. Only thereafter have they paid that 5 lakhs to me. And the last, no, and 2 lakhs is yet pending, is pending as yet, your lordships. If I may just point out that for that 2,000 rupees, which my learned friend is talking about, that he's giving me as maintenance, for that first they had filed a review petition before the Honorable Family Court. Thereafter, they came before in a CRP before this Honorable Court, saying that 2,000 is too much of an amount to be granted as maintenance. This is on
No,
record, your lordships.
no.
This is on record.
Let me understand the issue.
Lordships.
Now in this criminal revision petition,
Lordships.
the order of granting 10,000 per month
Lordships.
till the realization of alimony has been under challenge.
Yes.
He has challenged it.
Yes.
In this revision petition. And in the interlocutory application,
He's asking
He's
for a stay.
asking for stay of that.
Lots.
Okay,
Because
now
the quantum has now turned up to be 9,20,000, which is the
arrears
execution
have
petition.
accumulated.
Yes, the arrears have accumulated, and in fact, your lordships, the learned family court at one point of time had called him inside the chambers, counseled him that you take it at 8,000 and we will cut it at that. He was given time to think about it, and instead of thinking about it, he vanished. So naturally, his conduct has been such, your lordships, that the
Yes, now.
what can I say?
Now you can.
My lord. May I proceed, my lord?
Yes.
The order has passed by the family code under section 125 CRPC is not only erroneous, but also inconsistent with the law and hence not sustainable. The reasons as given by the family code is it is very poorly reasoned and very ineffectively analyzed. Consequent thereof, the outcome has been very unfortunate because the decree has passed. The critical amount of 2,000, whatever it is, it ought to have been put into effect. It ought, anything that is paid under a decree should be taken into account against anything which may be ordered to be paid by the family court. Over and above,
No, I'm not understanding.
under section 24, whatever amount has been granted, under section 24 of the Hindu Marriage Act, whatever amount has been
No,
granted.
okay, let me put one more query. Whether the order under 125 was passed earlier or the maintenance order,
And
the
section-
divorce was earlier.
And the order under section, no, it's subsequently, it is
This
very
was
same order,
subsequently passed.
very same order.
125 was subsequently passed.
Or, but then here in this case, the order of the 125 as well as the divorce has been incorporated into one order.
No. Two separate judgments delivered in two separate proceedings, but on the same day, your lordships. On the same day.
Same.
Yes.
It has to be two separate.
Two separate judgments delivered in two separate proceedings.
Because one has to be a divorce case, other
Yeah.
has to be maintenance case under
Yes.
120.
Just the date of the judgment is the same, 29/9/2023.
But two
That is all.
separate proceeding, two separate judgments.
Judgments. Yes, sir.
But the interim
But
order.
on the same day.
On the same
Same
day,
day.
yes.
Okay.
It's not same day.
Now what is your submission?
The order has passed under section 24 for interim maintenance has not been explained and ought to have been explained, while the order has passed under section 135 has been passed. So
There is some order for interim maintenance also
there is order for interim maintenance also, madam, under section 24 of the Hindu Marriage Act.
in other proceedings.
Yes, there are three proceedings. There are three proceedings altogether. The interim maintenance as passed under section 24 of the Hindu Marriage Act. Already it has been carried out all along.
How much was the interim?
Interim maintenance was passed, my lord, at the rate of 2,000 rupees a month, and 5,000 rupees were paid as
What
expenses.
was the order, date of the order
Date of the order.
and case number?
Lordship, that was Ms. J, case number 34 of 2016. The order was passed on 16/11/2016. 16/11/2016.
It was miscase of the main divorce case.
Yes, your lordships.
Okay.
Whereafter, if I may just also add that he had thereafter filed a review petition for reducing the quantum of 2,000. Thereafter, when that was dismissed, he came to the High Court. He filed a CRP before the Honorable High Court. I can give the numbers if your lordships want.
So he's.
For 2,000 rupees.
For
your
not
lordship.
paying.
For
That is-
reducing the quantum of
Okay,
2,000
So
rupees.
he's reluctant
He-
in paying.
Absolutely. What can I say? And in fact, we had to file a contempt petition for him to pay the amount to us. That was the situation, your lordships.
Yes.
That will be taken, that will be taken note of at the proper time. My lord, we have challenged the order has passed under section 135 of the CRPC, and the detailed arguments will be provided at the time it is after all finally, and totally was hard, it will be taken care of. The woman, the wife was educated and she was an earning member. She had, in receipt of money, she had a little back locker. She has earning, she was had the capacity to earn, she can look after herself, and she was getting money also from government organization. So in fact, she was not entitled to at all to get maintenance from her husband. And the marriage was dissolved on the ground of cruelty perpetrated by the wife against the husband. On parity of reasoning, if cruelty becomes the ground, if cruelty becomes the ground for the dissolution of marriage, that cruelty perpetrated by the wife against the husband on parity of reasoning, she is hardly entitled to getting compensation, such as in case of adultery, and in case of desertion, the woman is not entitled to get compensation from her husband, or whatever it may be. But our contention is this, that for the time being, until unless this execution order is not stayed, then this revision petition will be of little avail. Because if this process we shall not be able to reverse the process once this amount is being realized by the family court. As such, is a humble prayer that once the LCR has received in this court, and when this revision petition is finally and totally disposed of, we shall abide by the outcome, whatever the outcome, we shall abide by the outcome of it. But there are a lot of wrongdoing in this order of Section 25 CRPC has passed. In fact, this order is itself inconsistent with the provisions of law. Also, it is not sustainable.
How it is inconsistent?
Inconsistent two ways, my lord. One, the revision petition, this maintenance as granted under Section 135 does not explain how it has fixed the amount of 10,000 rupees, despite there being an interim maintenance under Section 24 of the Hindu Marriage Act. It also does not explain, over and above that, how this maintenance order will put to effect retrospectively 8 years prior to the date of the order. The accumulated amount has come to around 10 lakhs only because it's a retrospective order with effect 10 years back. This was
It was from the date of filing of petition.
Date of filing of petition.
But that is the law.
Though that is the law, there is the explanation about it, my lord. There must be reasons for it. That is the law, as per our understanding goes. Without any reasoning, even arbitrarily an order is passed, that the area will accumulate from the date of application. That is highly defective order. There must be explanation thereof. And the other factors which should be taken, which the lordship is pleased to address me, then there are other factors which ought to be taken note of by the family court while disposing of the petition under Section 125. The petitioner did not take care of at all. This court failed to take note of one fact, that whether his wife was an educated woman, whether she has the ability to earn or maintain herself or not, whether she is a bank local, she has admitted that she had a business of her own, a cloth business, and she is earning money out of that. Despite all that, she has been most whimsically, this order has been passed. Had it been a reasonable and reasoned order, there has been no objection from our side to comply with the order. Because we have found the outcome of this order is very unfortunate, we had to come over here to the Honorable Court with a revision petition, which made kindly, which the court will be pleased to hear. Over and above, my lord, if I can say so, if this money is realized, this process, they are waiting for 8 years, 8 long years they are waiting. What is the harm in waiting for another 30 days or 25 or 15 days? When the petition comes over here, it will finally dispose of, finally, and totally can be disposed of. In that case, if our revision petition is dismissed, we shall definitely have to pay. They are in a hurry to do it. And in a hurry, if it is carried out, then how can we reverse the process? We cannot reverse the process at all. Consequently, we shall be prejudiced and it will suffer such irreparable loss that it will not be possible to undo what is being done in the absence of the state of this order. That is why I have come over here. Otherwise, you not stop. There are many other factors which are to be taken note of, have to be decided when the revision petition is taken up for hearing. No other reason. This is the only way. So, because we have found, totally we have found, if we have gone through, the order itself is very unreasonable. Order itself is not based on law, and order itself is not at all analyzed. How can an order be there?
Your submission is that the impugn or
Yes.
order is poorly reasoned.
Yes,
It's a wrong order,
wrong order. Court is not at all analyzed.
and therefore it is during pendency of the revision petition,
Yes,
the operation of the
it should not be done
it
because,
should be
yes,
stayed.
over and above.
That is the limited.
One more,
submission.
my lord, over and above, if it is carried into effect today, then it will not be possible afterwards to reverse what the family court puts into operation, and it will get the prejudice because of the petition. And over and above, if I can bring it to the lordship's kind notice, here is an exceptional case, a case wherein divorce has been granted to the petitioner, to the plaintiff, to the petitioner, on grounds of cruelty committed by the wife against the husband. And a large number of cases where the husband has been acquitted. In series of cases, in plethora of cases, the husband has been acquitted by in large number of cases
The divorce was granted on the
on grounds of cruelty perpetrated by the wife against the husband. So on parity of reasoning, this ground itself disentitled her, disentitled the woman to get any compensation. Just as in case of desertion, just as in case of adultery, the woman is not entitled to get any compensation. Like in that nature, cruelty when it is committed, the woman is not entitled to get any compensation. That is our main contention, my lord.
Okay, finished.
I think, my lord, justice has been not justice has been co-deserved by the family court, and I do hope and pray that justice will be adequately served only if this is stayed for the time being till this revision petition is finally disposed
No,
of.
One query. Rightly or wrongly, this has been granted for maintenance of the wife.
Correct, my lord.
So if we stop it, how she will maintain herself?
Right, my lord. But
Because there is a finding that she is unable to maintain her.
those aspects you have gone into, my lord. Those aspects we have to go into detail. She has her own business. She is so wealthy that she has a locker of her own, maintaining the bank.
But those submissions were
Those submissions,
not found to be.
that is the reason why, my lord, we have challenged this. The maintenance order there here is High Court. The order has been whimsical, order has been very arbitrary, and over and above, she is already getting a maintenance or under interim maintenance is getting under section 24, the Hindu Marriage Act. That aspect has not been has been overlooked altogether by the family court.
You are presently paying the interim.
Yes, we are presently paying, my lord. We have also paid recently on 4th of March, 5 lakhs of rupees.
No, Lordship will not conclude
No,
the
no,
5 lakhs. 5
my
lakhs is for
query-
the
Whatever it is.
permanent, no, whatever it is, what do you mean?
No.
5
Let me
lakhs.
complete, please. Let me complete. You will have your time to speak.
You're
You will have your
confusing.
sufficient time. You will have your. Why do you interrupt? I am not
Please don't make
interrupting.
wrong submission.
No, I am not wrong. Maybe
No,
because
no.
I have got all the reports with me today.
No, you
I have
don't,
come only for the stay of it.
don't fight like your client.
No, not at all, my lord. I have highest respect for her. She is a reputed anchor also in this High Court, as I've seen her. But point is that
Let
the
let me
family.
put query. Let me put query.
Oh, yes, my lord.
The interim maintenance allowance which you are paying, what is the quantum?
Quantum was a fixed, it was fixed, my lord, in the year 2016. That maintenance fixed in 2016. That is nearly 8 years or 9 years back it was fixed.
No,
And
no,
it has been continued to pay. But my
You-
point is,
No,
my
no,
lord,
you have not answered my query. My query
but
was. what-
2,000 rupees a month, my lord.
Yes.
That is,
Now this 2,000 you are paying regularly or not?
I am giving to know this paying regularly.
You are paying
Yes.
regularly.
Or since
I am giving to know at least. It is not paying- The petitioner is not here.
So
to
your
pay.
submission is that in view of this regular payment,
Yes.
this payment of rupees 10,000 which was granted by,
I am not
Then-
against the payment of whatever amount the family court pays it. I am agreeable to that. But my only difficulty is, my lord, in complying with the family court's order, it was not rational. It is not found reasonable. I am not the finding it is consistent with law. Because only 5 lakhs rupees have been paid. Family court has paid the entire paid for amount of 20 lakhs rupees and interim maintenance for the wife. Though that family court has granted her divorce on grounds of cruelty perpetrated by the wife against the husband. And also family court has granted her an interim, a permanent alimony of 20 lakhs of rupees plus 20,000 rupees for cost of proceeding. And we have already paid her the
No,
first.
that is not before me. Now, before this court only,
That man.
question is that if you have not paid the permanent alimony,
Yes.
till then you have to pay
We
rupees
we shall
10,000.
continue to pay it, my lord. Only my only submission is that let the revision petition be finally disposed of. Only till the disposal of this revision petition, which has been admitted on motion stage, only for this time, interim period, this execution of the order, this payment may be stayed in the interest of justice to the petitioner, not anything more than that. Only because they are already waiting for it for 8 years or 9 years. Now, what is the harm in waiting for it for another 30 days or 50 days? Once this revision petition has been disposed of, we're bound to pay it, we shall comply with it. That is my perception. Only this, interest just because this particular order as passed by family code under section 125 CRPC is not only unreasonable, there are a lot of mistakes in this order. And this order has been, the order has been challenged.
Yes, yes.
And over and above, I will hesitate to say, just a minute, I will hesitate to say,
There are 3 parties.
no, my God, 2 parties. Husband, I am hesitant to bring it here that a false affidavit has been sworn by your wife in the family code in respect of her assets and liabilities. And yes,
In 125 proceeding.
yes, ma'am. No, in the proceeding as submitted, in the proceeding of dissolution of marriage and proceeding of permanent alimony, I am hesitant to bring it to the notice of this year. But I have been compelled to do it. I have been compelled to do it today because without bringing it to the notice of the court, no justice can be made. Because a false affidavit is sworn in respect of her assets and liability statement. She has said that she has borrowed money on bank on her mother's debt. Mother's death took place when? Mother's death took place January, but she referred to mother's death taking place on 23rd of March or so. We shall have to verify, but this is the content, my content. These are many factors are there combined together. Only what is a pressing for that stay, the operation of stay, this operation of the order only for a few days so that our petition, criminal revision petition can be disposed of fully and finally, nothing more than that. Once the petition is disposed of fully and finally, we shall abide by whatever the order is.
No. In the IA, we have accused a notice from the family court at page 12, my lord. It is annexure B. In this notice, my lord, we have been asked to.
At page 12. Page number 12.
20,000. And this IA cause of action for this
No,
IA.
page number
arose
12
due
is
to
not,
this notice,
not
my
in,
lord.
not in. Page number
12,
12 of the IA.
IA, yes.
12
Annexure
of
B.
the IA is an order of the division bench.
So this is the notice issued by family court for payment of area.
Page 13, your lordships.
13 is also not in notice.
Lordship, 13 is the notice of the family court in the execution petition which has been filed by us. At least in my copy, it is marked as page 13.
No.
Lordships, I'm sorry. I apologize. That is what they have served on me.
Well, this is annexure. This is the notice.
Notice is at page 11.
Lordship,
Annexure
in my
B.
copy, it is at page 13.
Annexure B.
Annexure B, yes, your lordship.
Yes, at page
Yeah,
11.
Page 11. Apna page 12, move page 13.
This is the notice of the family court. Lord, after we paid rupees 5 lakh as part payment of the financial living allowed, they started the execution of the 125 proceeding. Now, my lord, in the 125 proceeding, they had submitted an affidavit regarding exception liability. my lord. And in that affidavit, there are many facts which are false. And we have filed a rejoinder in our net appeal that court should take notice of those false facts shown in the affidavit, my lord. Now, the family court during while disposing of the maintenance case did not take into account all the material facts, Your Honor. First point is that it took about 25 days for conciliation between the two parties. Therefore, my lord, the wife, the respondent, was not very sincere in prosecuting the proceeding under section 125 CIC. This case, that case was dismissed twice, my lord, in the family court.
Lordship, that is an absolutely
after
incorrect
several
statement of
months-
fact. It is absolutely incorrect. It has never been dismissed. Your Lordship will call for the records and find out the case has never been dismissed for default. This is the statement. I'm not sure where they're getting this from. They have not annexed any. If it was dismissed for default, where is the order? Why is it that you have not annexed that order in your petition?
No, no, no.
देखो आप दिखवाई दो, please. अपना revision petition दिखवाई दो.
No,
बहुत
it
अच्छे
is in our pleading. Pleading court of state, he brought it. Family court.
If I can bring it to the notice of it, just with lordship permission. Honorable High Court asked two or because it's possibly diverse petition. Diverse proceeding was very, very long pending there in the family court. It continued for more than 8 years. Subsequently, as a result whereof, we had to move twice this Honorable High Court for a speedy disposal of this diverse petition here in family court. Once the Honorable High Court passed an order for expeditious disposal in the family court. That apart, second time we have to move again, Honorable High Court for disposal of the diverse petition there in family court. That time, this court directed the family court dispose of this petition, diverse proceedings within 6 months fixing time. Despite that, the proceeding continued for years and years together. Those are in record. We can produce it. We can produce it. This Honorable High Court twice on 2 occasions passed 2 orders. One for expeditious disposal of the proceeding in family court. Second time, fixing a date of 6 months, this High Court passed an order to dispose of this proceeding with 6 months time. Those are also violated. Those are violated. And beneficiary of all these prolonged disposal, prolonged proceeding was only you. Over and above this respondent, right? She was the beneficiary of order scheme. She's getting money under governments of India's order scheme that has not been noted here. She has a prosperous and business in Beltola and cross business that also has been not properly verified, not properly stated. She has a business there. She has the bank lockers. Those are being kept in secret.
No, these questions I am not in a position to verify now. Now, this court is concerned only with a limited
Right.
question that whether during the pendency of the criminal revision petition, your interlocutory application for stay of the maintenance of rupees 10,000 per month should be stayed or not. That is the limited question. You are mixing. I cannot look into.
Only whether the stay for maintenance, the limited question of staying the maintenance of all our prayer, humble prayer is, my Lord, that it will be stayed only for a short time so that our revision petition can be finally and fully disposed of, and it will be disposed
Your
of once the
submission
records
is
come.
that
it will be disposed of.
the balance of convenience lays in your favor if the matter is stayed. If the matter is not stayed, how would you be prejudiced? That you have to only satisfy.
Because right, that is the one factor. Because the areas has been allowed to accumulate to the extent of 8 lakhs, which is going to cause immense hardship to the prisoner.
For that, you may make prayer before that court. But if a stay is given, it will stay even the monthly maintenance. It will amount to stay of grant of monthly maintenance of 10,000 also.
No. Our prayer is that only because this prayer was there in the revision petition itself. But somehow as the revision petition, revision petition, records were called and we thought that it would be disposed of within 1 month's time. But then that has not materialized because in disregard of the court's order of 4 months, of 4 weeks.
Okay,
Record has not been sent up here. So the matter is not coming up in the court. And we are not in a position to place all the facts and particulars before the court. Because we expected that in 4 weeks' time, the matter will be heard once again, once it's admitted. But it is 6 weeks' time, more than that. The record is not coming forth from the lower court below. It is in total disregard of the High Court's direction. Consequently, we have not been able to place all facts, all particulars before the revisional court in that. That is our problem. And that is the reason why we have prayed before your lordship for a stay of this order, of Pavilico's order for limited period, so that we can place all the facts and particulars in order that the court can arrive at a most reasonable decision.
Yes, yours. Why this notice is relevant, annexure B? Annexure B, you are referring to, no, you are referring to, Mr. Das, you are referring to annexure B.
You were referring to
Notice.
document, ये तो की और करने relevant हुआ है,
Yes.
ये notice notice तो की और करने relevant हुआ है, वही ऐसा. ये notice तो
You are
हुआ है ऐसा.
pointing something toward regarding that notice.
Hey, why this notice is relevant? Why this is notice is neutral? This is the reference.
You were referring to it.
Yes, ma'am.
So why you were referring, I could not understand.
If I can help
I am living the difficulty when I don't know.
my lord,
Little bit high.
notice is relevant because the entire matter has been now hurried through. The hurrying through it will create a problem of doing justice to all the parties. The matter has not been buried in so long. Now it is hurried all of a sudden. Once the revision petition is moved in the High Court. So it's not in a hurry, because once it is hurried, the problem would be that once it is being executed, the revision petition itself will be avail, and we cannot be able to reverse the process thereof. If the revision petition is set aside, not allowed, if the order in section 1 to 5 is upheld, we are bound by it. That is my conflict. We have not been in a position, despite nearly 1 month and 15 days are over, we have not been able to back up. We have not been able to place all our facts for the division.
Yes, anything else?
My lord, in my opinion, my lord, we have gone through the judgment of the family court in 125 proceeding. There they have considered so many things. The principal judge considered so many things. And one thing is there, wife had liabilities to pay something to her mother. In that affidavit for assets and liabilities, my lord, she claimed that her mother died on 1st of January and she took loan about 3 lakhs from a bank for treatment of her mother in the month of March of the same year. After death of the mother, she took loan for treatment of her mother in the month of March, my lord. That is clearly wrong, false affidavit, my lord. So that type of thing, many things are there, my lord, in the affidavit. And the learned law court did not analyze all those things and came to a conclusion that 10,000 should be given to her, which is for the date of filing of the petition. Yeah, our prayer before court, my lord, that the learned court committed mistake in ordering payment of maintenance from the date of filing of the suit, filing of the maintenance order, and also the learned court was wrong in appreciating the affidavit for showing shown for assets and liabilities, my lord. So there are so many grounds to interfere in that order. And for that reason, my lord, we have paid for stay of this order. And if it is not stayed, we have been asked to pay rupees 9,20,000 today, my lord. And in the meantime, we have paid rupees 5 lakhs in negotiation, my lord. And another 2,000 per month indemnity is being paid. So this order maybe there is merit, my lord, and it may be stayed for some time.
Yes.
Very much.
Lordships, I'd like to place before your lordships to a set of documents, which is the assets and liabilities which have been filed by the petitioner herein before the learned family court. He has deemed it fit not to annex this portion. Yes, chart to back. There is another chart which I'm placing, which I will come a little later, your lordships. This is the entire bunch of his documents which he has placed before the Honorable Family Court, your lordships. If I may take your lordships to page 31 of this bunch.
This is filed in this 125.
125 petition.
So it will be in the record.
It will be in the trial court record. Yes, your lordships.
Record has arrived actually.
It has?
LCR and Senate. Oh, yes, yes, you may.
Lordships. Perhaps it is there. I'm not sure. In any case, I'm placing it before your lordships. Page 31, your lordships. What we had pointed out before the learned family court are the various transactions which are being made from his own bank account towards mutual funds and towards SIPs, your lordships, and also towards loans. I will just point out, if you also just have a bare glance at this thing, there are certain debits which are going on a monthly basis, 3,000, 2,000. These are all his fixed mutual funds where he has invested. And next page, page 32, the same thing continues. Figures are very clear that there are several mutual funds that he has, 10,000, 5,000, 10,000, 2,000, 3,000, several, your lordships. Page 35, also the same. I won't bother you, your lordships, with all of this. Then your lordships will perhaps turn to.
This is to show what?
Lordships, that is his income, the capability, your lordships. One or two things which I must point out to your lordships are at page 98, if I'm not mistaken. Page 98, your lordships. Your lordships will find the third transaction from the top. Page 98, Axis Bank. Your lordships have got it? Yes. Now, the third transaction from the top, your lordships, it is 14/10/2022. Your lordships have got it? 14/10/2022. The third transaction from the top.
Yes.
Lordships. Now, this is a transaction. It is an IMPS, which basically means it's an interbank transfer. And it is for an Adidas shoe. You also got it? ADSHOE. It is for an Adidas shoe. And the quantum is 2,11,000 rupees. Next, your lordships. Next transaction, 15/10. Perhaps this was maybe the thing backfired.
You have to also say why you are showing it to me.
Yes, of course I will. I'm just going to that. 16, your lordship will go to 16/10/2022. Another Adidas shoe, 3 lakhs. 3 lakhs. Then 17/10, again some other shoes, 1,90,000.
So you may be having a shop.
Lordships, he's a dentist by profession. If he has the habit of displaying shoes in his dentist clinic, I'm not very sure. But then your lordships will continue to page number.
Now what is your submission?
I just wanted to finish with these documents, then I'll submit, your lordship. Page 101 for a moment, your lordships. This is the registration of his vehicle, which is a Hyundai Creta car. Then your lordships will come to page 102. This is a registration certificate of his Hyosung bike. To my knowledge, it starts at 3,90,000. To my knowledge, your lordships. Next page, your lordships, page 103. This is the registration of an Interceptor Royal Enfield. I'm sure there are several young men lined up in the court who will be able to fortify my statement that these bikes are no jokes in the sector of motorbikes. Next, Your Lordships, there's something called Continental GT Royal Enfield, page 104. Then Thunderbird Storm 105.
Who is the registered owner?
The petitioner
Petitioner is the registered owner.
of all, he has 7 such bikes to his name, apart from 2 vehicles, other 4-wheeled vehicles. 106, Your Lordships. Truckstock Triumph MCs. 107, also something else. Now, the reason I'm placing all these documents before Your Lordships, Your Lordship will perhaps indulge with me for 2 minutes and take the criminal revision petition, which was, when they filed this thing, they did not serve a copy on me. Now, throughout the entire proceedings in the matrimonial, in the divorce case, as well as in the 125 petition, the case of the petitioner has been that I am competent to earn money. Your Lordship, I have very frankly made statements before the Honorable Family Court that after I left his home, since I was a graduate, I was not being able to find a job. So I have taken up a small shop on rent, and I try and run a garments business there. I sell some mekhla sadar, some kurta, something like that. All along, they have been relying on a document at page 98 of the criminal revision petition, page 98. This is the single document that they rely on to show that I am able to earn a living. I have made a sale of 700 rupees. And he buys shoes worth 3 lakhs and 2 lakhs. And he says that he cannot pay 10,000 rupees. It will be absolute injustice to him if the quantum of alimony is paid, or the quantum of maintenance is paid to me. This is the single document which they have been able to produce to say that I am earning my living. I have never denied that I am trying to earn my living because I have to live. I will have to survive. It was a marriage of 10 years.
This affidavit of assets and liabilities was submitted by
The petitioner,
he.
by him.
Okay.
Yes, Your Lordships. It is his documents. It's not like, because we cannot, how can I have access to such documents, Your Lordship? These are all his bank statements. He is the one who has placed it before the Honorable Trial Court. Now, if Your Lordships will take up the interim application, no, he has not annexed the judgment here also, Your Lordships. In the CRP, Your Lordships will take up the main order, which is sought to be stayed by way of this interim application, interlocutory application. That starts at page 123, annexure 17. After discussing the basic facts of the case, Your Lordships, at page 129, the learned court below framed 3 questions, Your Lordships. Page 129. Have Your Lordships got it? The first question was whether the wife has left the matrimonial home with just and compelling reasons, or she has voluntarily left her matrimonial home and is unable to maintain herself. This question was answered in the positive in my favor. Whether the opposite party having sufficient means refuses or neglects to maintain the petitioner, and whether the petitioner is entitled to get any maintenance or allowance, if so, from whom, and what shall be the just and proper amount of maintenance. Now, my learned friend has been submitting that it is a very poorly reasoned order. This is the submission which is being made at least 4 or 5 times. The words which have been used are, it is a very poorly reasoned order. Your Lordship will kindly turn to paragraph 13 of this judgment at page 131. I'm going to read a few paragraphs, Your Lordships. So far, the income of the petitioner is concerned. Till paragraph 12 is the reasoning about whether I left the home, the matrimonial home, under compulsion or not, because that is not the subject matter of this particular, of the submissions made by my learned friend. I'm not bothering Your Lordships with that. Paragraph 13. So far, income of the petitioner is concerned, the petitioner, though pleaded that she has a garment shop at Beltola, but except producing a paper slip of selling 2 kurtis, that too without any name of the firm and the owner, it cannot be said that the said shop belonged to the petitioner. It may be mentioned here that the petitioner in her pleading and evidence claimed that while she was in the matrimonial home, due to non-providing financial assistance for daily needs, she was compelled to start business and same was closed thereafter. In her affidavit of assets and liabilities, the petitioner has stated that presently she has no income of her own. In her cross-examination, she denied having any income of her own, and this part of her evidence on income is found believable. Point number 2. So far, the income of the opposite party and the payment of maintenance of the petitioner is concerned, it is the case of the petitioner that since living separately, no maintenance was paid to her except an amount of rupees 2,000 per month as directed by this court in Ms. J case number so-and-so. Even against this, the respondent husband has moved the Honorable Guwahati High Court, and on rejection of his prayer, he was compelled to pay this amount. There is no dispute to the above facts. Admittedly, opposite party did not pay any amount of maintenance to the petitioner. The wife is entitled for respectful life at the standard of her husband. So far, the income and profession of the opposite party husband is concerned. Admittedly, he is a dentist having a private practice, and all his family members are gainfully employed. His father is a retired regional passport officer, and his mother is a retired senior government official in the Family Welfare and Health Department, Government of Assam. His brother is a bank officer, and his sister is a lecturer in the university. Thus, the opposite party has no responsibility towards his other family members. In his affidavit of assets and liabilities, the opposite party husband has admitted and disclosed his monthly income about 40,000 rupees to 50,000 rupees per month. It has also come out during cross-examination of the opposite party or husband that he has 7 numbers of high-end international brand motorcycles and 1 Hyundai Creta vehicle, which shows the luxurious life of the opposite party. With his regular income from dental practice and without having any other liabilities to other family members, apparently the opposite party has failed in his duty to provide proper maintenance to his estranged wife, which he is otherwise lawfully bound to do. This point is answered accordingly. Where is the, like my learned friend is trying to say, that it is a poorly reasoned order, Your Lordships? What more reasoning does my learned friend want? I read a little further. So far, the amount of maintenance to be fixed is concerned. The petitioner has prayed for granting maintenance of rupees 20,000 per month. This was my prayer. I have already held that the petitioner has no regular income of her own. Considering all the facts and circumstances of this case, admitted income of the opposite party, the luxury of having 7 motorcycles and 1 luxury vehicle, the opposite party has in his possession, and taking into account the fact that the opposite party is paying a meager amount of rupees 2,000 only per month in the Miss Case J towards maintenance, parental leave, and expenses of the divorce proceeding, I am of the opinion that it will be just and proper to direct the opposite party to pay rupees 10,000 per month towards maintenance of the petitioner. It is made clear that this monthly amount of rupees 10,000 is in addition to the amount of rupees 2,000 paid by the opposite party, which shall come to an end on disposal of FC civil case number 264 of 2015, like I have submitted. It may be mentioned herein that FC so-and-so filed by the opposite party husband for granting divorce is also pending today for judgment. In that case, judgment was delivered and the petition for divorce was allowed by granting a permanent alimony of rupees 20 lakhs to the wife. As such, asking the opposite party to continue to pay the monthly maintenance to his divorced wife, even after payment of permanent alimony amount, will certainly be harsh on his part. How balanced a judgment can this be, Your Lordships? As such, to make a balance of financial liability of the opposite party, it is made clear that this order of maintenance under section 125 shall continue till the payment of the permanent alimony amount fixed in so-and-so. It is also made clear that liability to pay monthly maintenance amount of rupees 10,000 shall be automatically stopped from the date of payment of the entire amount of permanent alimony by the opposite party to the petitioner. Until non-payment of permanent alimony amount for any reason, this maintenance amount shall continue to hold the field. In view of the judgment of so-and-so, Rajneesh versus Neha, this order shall be effective from the date of filing of the petition, that is with effect from 9/6/2016. Lordships, what more reasoning does my learned friend ask for? In my respectful submission, there could not have been any more reasoned and a more balanced order. It is not like the Honorable Family Court has given that 10,000 to me for eternity. Very rightly, the Honorable Court has said that it will continue only till such time that I get the permanent alimony. The moment he pays my permanent alimony, this maintenance will have to stop, which is the law, Your Lordships. In my respectful submission, there is nothing wrong with the order which has been passed by the Honorable Family Court. In fact, my learned friend keeps talking about hurried, and the fact that he made just one more thing about the matrimonial appeal, Your Lordships. In the matrimonial appeal, a time frame of 5 weeks was granted to my learned friend to pay an amount of rupees 7 lakhs. He is in contempt today because he has not paid the 7 lakhs. He's only paid 5. And there is no stay on the execution proceedings before the family court. So if I file a contempt case against him tomorrow, saying that the 2 lakhs is yet pending, I'm not sure what my learned friend is going to say. And besides which, let me finish, please. Let me finish, please.
Please.
Let me finish. I don't know which one of you wants to submit. Maybe as a third one, please invite him as well. Lordships, there's one more chart that I have placed before your lordships. That chart. No, this shouldn't carry over to this. Lordship, there's one chart that I have placed at a copy extracts out of development.
Which chart?
Lordship, along with that affidavit or
Yes,
assets and
yes,
liability, yes.
there is a chart.
Lordships, your lordships, the first page is about the various cases which have been pending insofar as maintenance is concerned. I'm not.
Between the parties. both
Yes,
parties.
between the parties, your lordships. And I will take your lordships to the second page. These are the other three cases which he has filed against me. He has filed a criminal defamation case against me for filing a 498A against him. He has also filed a civil malicious prosecution case claiming a damages of ₹1 crore against me. These are all cases which are pending, your lordships. And after acquittal, the 498A case went against me, your lordships. And after that, he has also filed a money suit of 1 crore. So the conduct of the petitioner before your lordships would perhaps play a big role in deciding the fact whether this order ought to be stayed or not, your lordships. There is a limit to making a woman run from pillar to post for something which is her legal due. And those two cases that my learned friend is talking about, that the Honorable Court had directed that the case should be disposed of at an early stage, without, naturally, the facts which were placed before this court were partial because a copy was not served to us. And on the first day of notice itself, they have said that we want a direction, and this Honorable Court in its own wisdom has passed those orders saying that yes, there should be this thing. The fact remains that it is mostly he who did not appear before the family court, your lordships, most of the time. And he ran away when, for counseling, the Honorable the Honorable Family Court had called him on 3 occasions into the chambers. In Lok Adalat, he has not appeared. Thrice the matters were fixed before the Lok Adalat. He's saying the 125 was dismissed on default. Absolutely incorrect. Let him show the order. If he was so this thing, why has he not produced a copy of the dismissal for this thing, non-prosecution? Absolutely wrong statements being made before this Honorable Court.
Record has been called for in this revision petition.
Lordships, I am mostly finished. I'm just placing before your lordships one judgment of the Honorable Apex Court, wherein the Honorable Apex Court has deprecated the system of stopping the maintenance in live law. Where's Lordships will find paragraph 3 of this. We are constrained to observe that this order shows total non-application of mine on the part of the so-and-so. This was a case where maintenance has been granted to a wife and to a minor son. The High Court, without recording any reason whatsoever, has stayed the grant of maintenance both to the wife and to the minor son. This should not be done. A husband or a father is duly bound to maintain his wife and child. Unless there are very special reasons, the higher court should not normally stay such an order. In the present case, no reason has been mentioned justifying the grant of the stay order. Lordships, in the balance of equities in my respectful submission, from what I have shown demonstrated before your lordship by way of the documents which I have produced, that his own assets and liabilities speak that he has the means and the ability to maintain his wife and much more. I am not asking for something which is not rightfully mine. I am not asking for his property. I am not asking him for anything which is not available to me in law. My respectful submission would be that this IA should be dismissed in limine with cost, your lordships. Deeply obliged.
Lord, in the criminal revision petition of 35, at page 20, my lord, paragraph 32, here we have mentioned that as per judgment of the Honorable Supreme Court in Rajneesh versus Neha, the date of payment of maintenance should be from the date of order. In under what circumstances, my lord? That has been explained there, and we are taking help of that case, my lord. So on those grounds, we have challenged the property of the family court order, my lord, and there are good grounds. On the last date, my lord, after hearing all these things, the learned court called for the record instead of passing any order on stay of the order of the family court, my lord. And again, it will be put up, and the matter would have been heard on the question of stay after receipt of the record. But in the meantime, Your Honor, they have filed execution case for recovery of the entire amount, slapping a notice on us to pay 9,20,000 in addition to whatever we have paid already.
Heard Mr. J.C. Chaudhary and B.C. Das, learned counsel for the petitioners. Also heard Ms. R.S. Chaudhary, learned counsel for the respondent. Let this case be fixed for delivery of orders on Mumbai on 1st of April. And whether any order has to be passed in,
Criminal revision is already, I think it is admitted, Your Lordship, if I'm not mistaken. And the records have been called for, or notice have been issued at least in the criminal revision.
in criminal revision petition, heard Mr. J.C. Chaudhary as well as learned counsel for the petitioner as well as Ms. R.S. Chaudhary, learned counsel for the respondent. The trial court record which was called for has arrived. This criminal revision petition is ready for hearing. Let this revision petition be listed for hearing after 4 weeks.
Lordship, the IA will then get separated from the
No.
petition.
Because I will be disposed of on 1st of April.
Okay,
Next Monday, I will be disposed of.
Lordship.
Tag this case record along in IA Likhibo. Tag the record of this case along with the case record of criminal revision number 35/2024.
Or perhaps Your Lordship may pass that order in the criminal revision petition on the day, on 1st of April, when Your Lordships are disposing of the IA.
Today, no order was recorded. No, because
In the
today
criminal revision, Your Lordship need not pass any order today. Your Lordship may just say that today in view of the order passed in the IA, let it be listed on 1/4. And on 1/4, Your Lordship may then place it before on
this
4.
is item number
37, Your Lordship, 37 and 38, if I'm not mistaken.
37 and 38, both are listed actually.
Yes, Your Lordship. In the criminal revision, Your Lordship may perhaps,
That
in
cannot be incorporated.
my respectful submission, perhaps may be listed along with the IA on the next date, on 1/4.
But it makes no difference.
Lordships,
Because
as per Your Lordships,
otherwise-
I have no
otherwise it
difficulty.
will Go for hearing.
Lordships.
So after 4 weeks, that will be heard. Your revision petition will be heard after 4 weeks. It is ready for hearing. And I will be disposed of on 1st of April.
Lordships. But without the case record of CRP, the IA
No, both will be tagged
will
to
be back. Lordships. Deeply obliged.
IA Rakhi. RO.
Right.
Amrita. Yes, next.
My lord, my item 7 was, my lord, fixed at last item, my lord. But I was not even informed about that, my lord. Only a small question is there, my lord. There is a stay operating, my lord.
Now, what is your prayer?
My lord, if it is not taken up today, my lord, then if lordship can take up, my lord, it's item number 7. Only limited question, they are saying
But
that
we will-
item,
The prayer is made fixed as last item.
but my lord.
How will we know when we are reaching the last item? When
My
lot
lord,
of-
I was not informed, the respondent was never informed about
who
that.
made the
The
mention?
petitioner made that.
Not I mean,
Not my lord.
up here,
It was my lord.
waiting for the
Learned
matter.
counsel, Mr. S.C. Biswas. From their chamber, my lord, somebody, and my lord, only a small question, my lord, because I filed an application under section 93, read with
No, but
406.
Mr. Vishwas has to be there.
Yes, my lord, junior is here. So, my lord, I filed an section 93 application.
No, we are
read
not
406.
taking up it now. We are deciding whether to take up it now or as a last item.
You know, I have a very urgency because from last 1 year, the matter is stayed, my lord.
Let us take it up as tomorrow at a fixed.
My lord, my lord.
Fixed time.
My lord. No, holy vacation. Achhi, okay, my lord.
Tomorrow, item number,
Item number 7.
item number 7.
7, my lord.
On request of learned counsel for both the sides, let this matter be listed tomorrow. You want a fixed time at 2 p.m.
2 p.m. Deeply obliged, lordship. Deeply obliged, lordship.
May please, your lordship, my lord,
2 p.m.
such lordship's indulgence, my lord, and convenience of the court. Item number 27, my lord, he's in custody for last more than 6 years. And there was an order, my lord, it's an NDPS matter. There was an order that if there is an IA, if the matter cannot be taken up for hearing after receipt of LCR, the IA may be considered, my lord. So I just leave it to my lord, my lord. I can understand, my lord.
Now, what is the matter to be called for in as 15? Now, what is your prayer? We are at 15.
My matter is for hearing, and there is an order earlier that after the receipt of LCR, if the matter cannot be taken up for hearing, the IA at least will be
Now,
considered.
that LCR has arrived.
Yes, it has.
So you want IA to be considered. When?
My subject to my lord, for me to even today, but I can understand the situation, my
No,
lord.
you at least you have to make a prayer. Otherwise, I will not understand what.
My lord, my prayer is that since he's been in custody in more than 6 years now, and
Because it is unlikely whether we will not reach 25 now.
mine is item 27, my lord.
27.
And
Then if we reach it by within half an hour, we'll take it up. Otherwise, we'll fix
I'll wait, my lord.
give a fixed date.
I'll wait, my lord.
So item 30, my lord, maybe listed tomorrow. If we don't reach
No,
there,
actually, what
if we don't
happened,
reach,
the mentioning time has not started. Because
I beg your pardon. I really
because-
beg your pardon.
Putul,
But we
he
are,
has stopped calling for the items, so you have taken indulgence.
I apologize, your lordship, but if it's possible, maybe listed tomorrow if it doesn't reach. Limited prayer,
Item number?
30.
Item
been-
number 30 unlikely to reach. But
Yes.
you can mention after half an hour
We'll wait. We're here.
because it may reach also.
Item 15.
Lordship, B. Sharma was there, but I think some matter has come up in another court.
Yes.
B. Sharma was there, Lordship, for the petitioner.
You are for?
I'm for respondent number 2.
Now what is to be done?
So part of it,
Appellant's counsel is not there. Yes.
we were very much there, but Lordship has some matter has come up in court number 20, so she had to write.
Fix it on some other day.
Yes.
Heard, Miss L. Devi, learned counsel for
Respondent number 2, Lordship.
respondent number 2. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned learned legal aid counsel Ms. B. Sharma was not found on call. Let this matter be listed after a week.
Obliged.
Item 16.
Right, please, Lordship. Also, the part heard matter, the last occasion was submitted about the maintainability of affair.
You are ready?
Yes.
Both sides are ready.
Yes.
Then other matters may have to be rolled over. Those now, if other lawyers are waiting, they may take dates from the court master. Mr. Chaudhary, this matter will take some time.
I'm on the schedule.
And this will consume the remaining half an hour.
So others may go.
Yes, that I am suggesting instead of waiting.
আমার দিয়ে খুবই দেন। আরে করেছে, পরিবর্তন এখান থেকে কোথায় করেছে?
Yes.
more than half an hour.
So others, those who have any special requests, they may make it to the court master. Otherwise, others will be shown as leftover and registry will list those fix a date.
That will much of. Chalo.
Yes, you may take silently.
Item 28, madam.
I have already said.
Lordship, item 31, Lordship, the wrongly listed the hearing list, Lordship, IA for bail, Lordship. 5 years already gone, Lordship. In orders column,
Item
Lordship.
31.
31, Lordship. In orders column.
Tomorrow. 31. Yes, this is item number
31, Lordship.
no 31 tomorrow. Tomorrow
Lordship.
we should come fix it. So this case has been wrongly listed in hearing column, listed in orders column on 22. Putul, এইটো কিমান item আছে? Yes, 16, Mr. Mojumdar.
The last occasion I submitted as how this matter has come after an appeal is filed before the Honorable Supreme Court. And I have read the contents of the FIR registered against me under section 188 of IPC and section
What
14.
was the last date of hearing?
Last date of hearing.
22/2. 22/2. Okay.
For refreshing my memory, if I may take your lordship to volume 1 of my
Yes.
paper group.
Just a minute. Yes. Yes.
Volume 1 of my compilation. At page 9, your lordship will find the FIR registered on 14/8/2019 for an offense allegedly committed on 8 October 2015.
Page 9 is the FIR.
Page 9 is the FIR.
Yes,
If I may read, my lord.
yes.
During the course of inspection in Tawang Township area by the land management team of DC's office Tawang, it was observed that Sri Jambe Sering, son of so-and-so, president of so-and-so, was found constructing building near Circuit House, Tawang, illegally without any land allotment order whatsoever. The ADC cum district estate officer Tawang had issued,
You are for Jambe Sherry.
yes, the petitioner,
He is presently holding the post
the
of
standing PP of Arunachal Pradesh.
Arunachal Pradesh. Okay. Yes,
The ADC cum district estate officer Tawang had issued notice under section 4(1) of the Arunachal Pradesh public premises, eviction of unauthorized occupant at 2003 to Sri Jambe Sering, giving him an opportunity to produce papers, documents, if any, relating to the land white number so and so dated 8 October 2015. Sri Sering was also directed to stop the construction of building and vacate the land within 7 days. No reply from Sering received. In the meantime, Sri Jambe Sering submitted a representation to the Deputy Commissioner, Tawang, referring to his earlier representations on dated 2/3/16 inter alia, admitting that he was.
Mr. NNB Chaudhary, you are also public prosecutor.
I am appearing as a public prosecutor. She is appearing for the informant, my lord, deputy commissioner, my lord. And Mr. Arun Chandra appearing for the state.
Mr. Arun
Arun Chandra.
Chandran. Now, one public prosecutor appearing against another public prosecutor. There is no conflict of interest
There is a conflict of interest, of course, my lord.
because you are also public
I
prosecutor.
am also public, so special public prosecutor is necessary. If your lordship, my lord.
No, just this question
That's true. That's
came
my
to my
lord.
mind
Yes, my lord.
because otherwise you are sharing same chamber.
yes.
Yes, my lord. We are
That's correct.
saying same chamber, we have discussed the other matter.
Who is
before.
senior
My lord,
in between both of you? Who is senior public prosecutor? There is any hierarchy? Who
I-
allots cases
my lord, I am public prosecutor, my
at
additional.
principal seat?
Yes, principal, I am a additional charge, my lord. Actually, I am additional advocate general, come public, prosecutor, additional charge.
Okay.
And he is public prosecutor.
He is public prosecutor of the state.
I am also public prosecutor.
Correct.
This is my additional charge.
Because this matter went to Supreme Court also.
Yes, my lord.
And because of the order of the Supreme Court, this case is now is in this principal
done
seat.
back.
Principal seat. It has
Yes.
not gone back to,
Yes, my lord.
it also has an history.
Yes, my lord.
Yes.
Why? Because this matter pertains to Arunachal. It should have been in the Itanagar bench.
The history, my lord, last occasion I indicated because of some conflict of interest,
Wonderful.
and it was sent back to this principal bench.
Your lordship, actually,
Because earlier,
our side had addressed the letter to the deed and chief justice. And there is a letter to the chief justice there in the file. Lordship, Sudhanshu Dhulia was there then.
What was
So,
the request?
Request to remand it back to the principal seat because we were under the impression that the last time it was the additional public prosecutors, meaning thereby somebody from the panel came and appeared for the respondent number 2 without any wakalat nama. He was not authorized to do so. Thereafter, we filed the complaint before the Bar Council. That's a separate aspect, Lordship. So we were apprehending some kind of similar acts again. We had written to the deed and chief justice. It's
Now,
there in the file.
now regarding Mr. NNB Chaudhary appearing,
Yes, Lord.
do you have any objections?
No, Lord.
In any party, do you have any objection? You may not be having any objection.
So I do one thing, my lord. Better.
No, if nobody is having objection, we will not change.
I do one thing, I shall wrote to the government, my lord, in this aspect of the matter to appoint another as a special public prosecutor.
Things will remain same. He will also represent government.
Yes, ma'am.
He is also representing government.
Yes, ma'am.
And here he is not as public prosecutor. And this fact must have been come to the notice of the Honorable Chief Justice, when your letter was,
There, the issue was slightly different. Here, the allegation was that somebody else has appeared on behalf of the PP without filing Vakalatnama. In my humble understanding, for appearing as a PP, no Vakalatnama is required to be filed. Because he represents the state, automatically it comes. It's a automatic transaction.
okay, no, let us proceed now because, and you have to proceed in a manner that this case has to reach its culmination. Now we have left with only 20 minutes time. Unlikely that it,
Yes.
so how to plan it?
Can be placed in on a
কাম
very
কৰোঁ দিয়া। বস্তু ক্লিয়াৰ কৰি লোৱা ভাল হ'ব আৰু। ছাৰে ঠিকে কৈছে মোৰ পাৰ্টটো মই এখন চিঠি লিখো। Lordship can adjourn this matter today, my lord. I shall wrote a letter to.
No, I am not insisting,
No, my lord. From myself, I write.
but this question only just struck my mind that
Yes.
both of you are
Public prosecutor, my lord.
Otherwise,
Whether
we
they
don't
say-
have any objection if he also appeared. Because it's a matter of question of law is involved.
No, objection may be of respondent, Ms. Chaudhary. If she is not objecting, you are representing the informant. Informant may object. If informant is not objecting, there is no issue. Then let us proceed with.
I was reading page 9, the FIR, how it started. I was in the third paragraph. In the meantime, Sri Jambe Sering submitted a representation to the Deputy Commissioner Tawang, referring to his earlier representations on dated 2/3/16, inter alia admitting that he has occupied the government land illegally since last 5 years and had requested the Deputy Commissioner Tawang to consider the case for allotment. While reference to his representation dated 2/3/16, the undersigned informed to Sri Sering the submission of representation do not ipso facto confer any right to anyone to illegally occupy government land and undertake construction of building thereon. And Sri Sering has also been informed that his representation cannot be considered by letter number so and so. Sri Sering has not submitted any reply to the said letter issued by the undersigned till date. Another notice was issued by the in-charge ADC cum district estate officer Tawang under section 4(1) of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003, directing Sri Jambe Sering to remove the said kacha building within 15 days from the date of issue of notice. Failing which, the said building will be evicted, dismantled, and the cost of demolition shall be borne by the building owner, file number so and so, dated 30th October 2018. It has been observed with serious concern that even after issue of notice, without bothering to reply, Sri Sering has undertaken the construction work of RCC building on the said plot of land. Further, the building under construction is adjacent to the government quarters and is touching the government quarters. As per the direction of the government by letter number so and so dated 1st September 18, for allotment of any land to any individual, the minimum distance required is 4 meters. Hence, there is no scope whatsoever for consideration of allotment of the said land in any case. In view of the fact that the following notices were issued by the ADC cum District Estate Officer Tawang, number so and so dated 25/1/19, we can skip some parts, dated 30th October, we can start from on 29th May 19, the notice was issued to Sering, white number so and so dated 29th May 19, stating that the said notice was last and final to remove the dismantle the structures within 7 days. Moreover, Sri Jambe Sering is in blatant violation of the law of the land is again carried out the construction work on the said plot of land. Again, one notice was issued to Sering on 18 June 19 by District Estate Officer Tawang to remove and dismantle the structure within 7 days, failing which the said structure will be removed, dismantled at the risk and cost of Sering. But Sri Jambe Sering has not bothered to remove the building till date. The necessity of filing FIR is due to the fact that even after issuing several notices by the District Estate Officer Tawang, Sri Jambe Sering has carried out the construction work. It is requested that the investigation may be completed and the legal action may be taken at the earliest. The details of the encroachment site will be given by Sri So-and-so, DLRSO Tawang. It is therefore requested to issue direction to register FIR against Sering, son of So-and-so. This is the sum and substance of the FIR lodged by DLRSO, come Deputy Commissioner, who under the Act of 2003 is also the appellate authority for an order passed by any estate officer. If someone needs to challenge the order has to be challenged before him. But here the important fact is the cause of action is very much important. The cause of action has started from the year 2015, continued up to 2019. But I will come to this later part of my submission. Then your lordship may come to the notice, the order and the notice issued by the estate officer, page 5. The notice dated 18 June 2019. This is the final notice given to me with a direction that if we,
This was prior to filing of the
prior to filing of the FIR.
FIR. In this case, what is your prayer?
But in this case, my prayer is to quash the proceeding, because as per the CRPC provision 195, a FIR cannot be lodged for an offense constituted under section 188 of the IPC. Another aspect is there in the charge sheet.
But the offense is not only under 188, it is.
14(1) of the unlawful, this 2003 Act.
This act. Okay.
I'll come to that also.
Suppose, before you proceed, suppose 188 is not maintainable.
Yes.
188, the proceeding under section 188 does not lie. Still, it may lie under section 14 of this act. What would be your answer on that?
But then I will have to refer to 468 of the Code of Criminal Procedure about the limitation part.
That aspect is there.
That aspect is there in the, not in the petition. I have not mentioned it clearly, but since it's a question of law, we may be permitted to raise it before this honorable court. Because the punishment is under section 14(1) is punishment is 6 months imprisonment or fine or both.
And there is a delay.
And there is a delay in taking cognizance.
So you are challenging both 188
Yes.
as well as
Yes.
14.
As a whole, I am challenging the entire aspect, entire proceeding. So
But for challenging entire proceeding, you have to specifically hit on some points. 188
yes,
is clear.
2 points
till now.
less.
And 14 is on the basis of limitation.
Limitation, and I will try to satisfy this honorable court going through the provisions, since an order is passed here. This notice dated 18 June 2019, specific order to demolish the building is passed by the authorities. Till today, they have not done anything. Because the order is very specific. If I do not demolish my building, then they will do. The cost of demolition will be reimbursed from me. But since 2019, we are in 2014.
No, but what relation this notice has with the criminal prosecution?
But entire thing has started from this aspect. The FIR was lodged on the basis of the notice. In the FIR, which I have read just now, there is a reference of the notice issued to the petitioner. This is a notice of 2019. The cause of action was arisen in the year 2015. And since then, my lord, they are doing idle without proceeding ahead as per the provisions of the Act.
Okay.
Well, I won't waste time of this honorable court. I may take your lordship straight away to page 6 of the final notice issued to me. The last paragraph. After explaining all those things, whatever is stated in the FIR, now therefore, I, so-and-so estate officer Tawang, empowered under section 4(1) of the Arunachal Pradesh Public Premises Eviction or Unauthorized Occupancy Act 2003, do hereby direct you once again to remove the building materials from the government land within 7 days from the date of issue of this notice, failing which the said RCC structure will be removed, dismantled by this office, and the cost of demolition shall be recovered from you. But I'm asking a question to myself that since 2019, since the date of issuance of notice, what action they have taken? Well, it's a personal animosity and nothing else. because once the petitioner appeared against the deputy commissioner in a separate proceeding in Tawang. So out of all this vengeance, this affair has been lost just to harass. Since 2019, we are in 2024, they are sitting idle. They are just harping on the matter, this FIR is lost. They want to pursue the criminal proceeding. But the proceeding which should have been initiated under the Arunachal Pradesh Public Premises Eviction Act 2003, they have not done anything. This is one aspect. My lord, just I want to show the malice, my lord, in prosecuting me in a way to defame me or to harass me. Then, my lord, after returning back to this honorable court, they filed a vacating petition for vacating the stay order. And after all, they succeeded in obtaining an order of stay. But after that, on the several days when the matter was not disposed of, there was a direction from this honorable court to stay the proceeding of the Tawang police station case, my lord, which is under progress. So afterwards, it was taken for final hearing. But in vacating the stay petition, this honorable court has made some observation, which is available at page 20. They raise certain points regarding not disclosing the fact of filing charge sheet before the court while obtaining the stay order, etc., etc. This court at page 25, paragraph 16, came to a conclusion that the filing of charge sheet, the fact of filing charge sheet may not be known to the petitioner since no notice was issued to him, no summon was issued, and they fail to show any from any record that any summon was ever issued to the petitioner. If I may read paragraph 16, I've gone through the case diary that has been produced which contain the charge sheet as mentioned above, but this court refrain itself of discussing the other matter in the case diary, save and except the stage of the investigation. It is an admitted position that the case has been ended in charge sheet dated 16/3/2020. And in view of that matter, while the investigation had already been completed in the year 2020, the stay of investigation in the year 2021 itself became infructuous. It is to be noted that at the time of passing such order, no status report of the case was obtained, nor there was any submission in this regard. So the court passed the imping order primarily on the basis of submission of the petitioner's side, respondent number 1. So far as regards the contention raised by the applicant side, the respondent was aware of filing of the charge sheet. The same cannot be brought on record as the LCR pertaining to the aforesaid case has not been produced as to whether any process was served upon the respondent after receipt of such charge sheet. Save and accept the order dated 28/5/2020 passed by the learned magistrate about the closure of the case. No any order of the court has been placed on record. So far, so good. It is an admitted position that the investigation of the aforesaid Tawang PS case number so-and-so has been completed as on 16/3/2020. And that being so, the order of staying investigation virtually become inoperative and redundant in the eye of the law. It was under that background the stay order was vacated, because by the time the stay was given by this honorable court, the investigation was completed. The earlier stay order was for the investigation, staying the investigation.
This case.
Yes. But by the time the second subsequent stay order was granted by this honorable court, the investigation was already completed. So the question of staying investigation does not arise. And it was under that background the stay was vacated. Thereafter, on the next page, your lordship will find page 27, relevant portion 28, page 28. It says, as no hearing has taken place today in the light of the aforesaid order and further in the backdrop of the averments made in the petition, it is provided that till the next date fixed, the proceeding in Tawang PS case number so pending in the court of learned JNC Tawang AP shall remain stayed. And this order is, my lord, continuing till today.
Okay.
Well, this is the sum and substance of the entire FIR and the proceeding initiated under the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003. And the failure on the part of the respondent authorities in proceeding with the act, the provisions mentioned herein, and the order passed in the year 2019, by which I was directed to demolish, and if I fail, then they would demolish the building subject to payment of cost by me. But still today, they have not done anything. So they are pursuing basically the criminal matter. So here, the provisions are mentioned in, if I may take your lordship to the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003. Yes.
Yes. Read 14. What you
Yes.
propose to read?
Yes. Well, the 14 says, if any person unlawfully occupies any public premises, he shall be punishable with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 2,000 rupees, or with both. Well, my offense perhaps will come under 14(1), because here, if any person unlawfully occupies any public premises, he shall be punishable with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 2,000 rupees, or both. The minimum punishment is mentioned, either is imprisonment for 6 months, or fine, or which may extend to 2,000 rupees, or with both. Before that, there is section 13, finality of the order. Save as otherwise expressly provided in this act, every order made by an estate officer or appellate officer under this act shall be final and shall not be called in question in any original suit, application, or execution proceeding, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. Well, there is a provision for appeal against the order passed by any state officer, which is available at section 12(1), the previous page.
So from where we will come to finding that anybody has, or somebody has been unlawfully in the occupation of public premises. Who will give this opinion? That you
But this estate officer, there is a notice, there is a finding, because I was given an opportunity to submit my show cause reply, and out of that, my lord, they issued a final notice.
So that has to come first.
Yes, but that notice just now I have read.
Whether notice
Section
is
4(1), my lord.
section,
The notice issued under section 4(1). The notice just now I have read before this honorable court.
so if a notice is given under section 4(1), will it mean that a prosecution under 14 may start? Suppose a notice is given.
It is violated by the section 4(1) notice has been given. He has not given the answer. Then section 14(1) will come in the play.
No, my lord, there is a provision after that, after 4(1).
If no appeal, will fine.
Well, if after 4(1), there is 5(1). But notice should be issued under section 4(1). The notice shall specify the grounds. Then section 5(1), if after considering the cause, if any, shown by any person.
Yes. It is 5(1).
Yes.
That after so and so, a state officer is satisfied
Yes.
that the public premises under are unauthorized occupation.
Yes.
Public premises are in. So this 5(1) satisfaction has to come before a prosecution under 14
Yes.
can be initiated.
That's what, my lord.
In this case, whether this 5(1) has arrived.
No, my lord, because from the notice itself, it is written under section 4(1). Means at the initial stage.
Notice, what is my understanding, both the sides I am putting query. Suppose I am in in possession of a plot of land. Estate officer thinks that I am unauthorized occupant of that plot of land. He will issue a notice to me under 4(1).
Yes,
I can make my representation, satisfy him. And thereafter, he has to come to a finding under 5(1) that no.
yes. That finding is not there.
If that finding is there, thereafter only 14
Yes,
prosecution.
exactly, my lord.
I don't know.
My lord, this is the law. My lord, that prima facie finding has to be arrived in under section 5(1). From the body of the notice itself, which is available at page 31 of my,
Nay, whether this notice has been followed by an order that
no,
of the estate officer that you, after considering everything, you have not replied to the notice, therefore I am of the
opinion,
not
consider
opinion.
My lord,
I
the
am
language is,
satisfied. I am satisfied that
yes.
the public premises is under
My lord,
unauthorized.
that satisfaction,
is to be there.
yes, it is not there. That's why the
Thereafter,
records were called for.
14 notice. Whether is this the case or
My lord, this
we can
precisely my
shorten
case.
up the hearing then.
This precisely my case. Second line of argument. The prima facie satisfaction has to be arrived in under section 5(1). And the notice itself it says 4(1). It can't be.
Then this, if this is the hearing line of your argument, then it may not take much time to dispose of this matter.
Yes.
Though the record is too bulky. Then when, today we are over with time.
Yes.
When can we fix it? We,
Next week. First week of April, 4th. 4th of April is Thursday.
American cases. How much time will you take?
Maximum half an hour. I have one volume.
You will finish.
Yes,
it.
yes.
And how much time you will take for reply?
I will take my lab 10 minutes. She will mainly argue. Because she is the
Informant.
commander.
Who is the informant?
Deputy Commissioner.
Deputy commissioner.
Okay.
Yes, ma'am.
Okay.
And he is the appellate authority also.
No, maybe, but
Yes, ma'am.
her replies matters.
Yes.
ma'am.
So how much time will you take?
15 minutes.
So within 1.5 hours we'll finish.
Yes, yes.
Yes.
So, सारी तारीखें क्या से? Okay, we'll fix it on 4th.
March of like.
Third, Mr.
As Vishwas.
S. Vishwas, learned counsel for the petitioner. Also heard Mr. Who is D. Majumdar?
He is my senior.
Dilip Mujumdar.
Okay. Also heard Mr. N.N.B. Chaudhary, learned public prosecutor,
For respondent number 4, ma'am.
appearing for respondent number 4.
Sorry, ma'am. 2, 3 and 4, ma'am.
Respondent number,
No, to be number. You 2. But I am 3 and 4, ma'am.
respondent number 3 and 4.
Yes, ma'am.
Also heard Ms. B. Chaudhary, appearing for respondent number 2. And the hearing remained inconclusive with the consent of learned counsel for both the parties. This case is fixed again on 4th of April as part heard later.
Yes, ma'am.
Oblige, madam.
That's all.
Achha, item number 30, there's an interim order for stay if that could be extended till the next day.
Interim order continue. Huh? Item number 30, on request of the learned counsel for the petitioner. You are for?
Also,
You are for?
Petitioner.
petitioner, let this matter be listed on 28th of 20th of March. The interim order shall continue to be listed.
আর তারিখটা লিখে নেবেন। এই ডেটগুলো লেখা তোমাকে তো